My lord, may I mention a matter, my lord? This is for enlisting the matter. This is upon notice, my lord. But the agency is that the corporation...
Give your slip, sir.
Your Lordship's time, may I mention item number? Your Lordship, original side is the item is 84. The three motor is expiring on 16th of next 16th next week.
Give your slip.
Yes.
Lordship, may I permitted to mention a matter, item number 78 of today's cause list, Your Lordship. There is some urgency. The illegal construction has been raised and almost completed, Your Lordship. We are suffering since 2020. Your Lordship. Great.
Your Lordship, may I have your leave to mention a matter for inclusion in the daily list?
Lord, item 138, Lord, for upgradation, Lord, the division bench has perhaps requested Your Lordship to consider, Lord, hearing this writ petition expeditiously. Urgency, my lord, being the petitioner is the flagship company of the Oberoi Group of Hotels. And one of their properties, my lord, is the Oberoi Grand in Calcutta, which is...
Where is the order of the division?
Yes, my lord. Kindly, my lord, see the last line, my lord. Last page, my lord, at the bottom. Second last line. Kindly, my lord, consider, my lord. The hotel has been closed for a year.
Let it come in the due course.
Grateful.
May I have your Lordship to mention in the combined list matter, your Lordship already decided the issue. In another matters, my lord, your Lordship already delivered judgment matter. See, that I will notify the authority, my lord, non-payment of pension and gratuity, my lord.
Give your...
I'm keeping.
Give your slip.
My lord, may I be permitted one extremely urgent matter, my lord, an appellate side list, my lord. The matter was mentioned before Honorable Justice Ravi Kishan Kapoor, my lord, having urgent determination and considering the urgency, matter was listed, but could not be heard, my lord, because, due to resolution of the bar, my lord. But I'm paying, my lord, kindly.
Give your slip, we'll see.
My lord, may I be permitted to mention, my lord, the matter relates to e-auction, my lord. The NIT was tender was floating, my lord. The petitioner's bid was wrongfully rejected, my lord, and we filed the petition, my lord, and the private respondent bid was accepted, my lord, illegally, my lord.
Give us the...
Mention the one matter, the appellates are inclusive the list motion. Urgent.
Appellates are not today.
It's
Lordship, I'm absolutely oblige you from you. So the thing is that on 5th there was another order, and when I was in the hospital and I couldn't attend. So what I would request, I've again applied for a restoration. Day before yesterday has been filed. Could you just give me dates? Because I'm now recovering from the operation, whatever. So
dates can't be given like this, sir. Whenever it will come, it will come.
Some judges do that favor since I am in person.
Oh, that's all right.
Some judges
we understand. We had restored your matter. Now you have to be here. All dates you can't just...
I can't follow, but because now I'm on rest basically. I've just come there so that if you could do it after the puja, a fixed date.
We'll see that, sir. Let the matter come.
Thank you, sir.
May I be permitted to mention one matter, Lordship?
I'll give that mentioning slip. Sorry. Okay.
This matter, your Lordship was pleased to allow the mentioning. The mentioning was allowed. Requisition was went to the department. Main file was brought to the court. And the difficulty is there is a restoration application pending in this regard, which the file could not be traced. I mentioned before your Lordship directed me to take appropriate steps in the department. Appropriate steps has been taken in the department, but till date, the file could not be deconstructed.
Go and mention before the registrar listing.
That has been done. I had already...
What is the outcome of that? We can't trace your files.
No.
That is for the registry to do.
That is, the difficulty is my lord has directed me to go to and reconstruct the file. I had given an application for reconstruction.
Yes.
After that, I have mentioned it in the register.
Yes.
Even that my file could not be reconstructed and the restoration cannot be completed. This is a pension matter, Lordship.
Whatever it is, I can't run the registry.
And if
Go and mention again.
If a direction can be given, Lordship, subject to your Lordship.
Not at all. Go and mention again before the registrar.
Great.
Lordship, may I permitted to mention a matter for non-prosecution.
Give the slip.
Sir, allow me to mention this matter. It's Group 9 application, Lordship. My clerk filed before your Lordship, Court Lordship. Kindly release the matter.
Give your slip, we'll keep it to be mentioned.
I beg
But
to
I
correct,
appear for
Madam.
the point number 7.
Previous occasion, already one restoration application filed by the only for the petitioner number 4. Therefore, Lordship also observed the other may be filed. Now the restoration application filed by petitioner number 3 and 5.
So, my lord, out of 8 petitioners, 3 petitioners have come in, my lord, till date. There is a section 5 application also along with the restoration application. My lord, I am seeking time to file affidavit in opposition to them.
Lordship,
Two applications.
I submit before your Lordship the
Want to file their reply to that?
the same application already filed before your Lordship and the restoration application already filed.
There is a
It
section
was
5. My lord will see if there is.
Section 5,
This
164
type
days.
of submission only for the restoration application more than 2025.
Sir, can you stop her from filing reply to the restoration application?
No, that
Eh,
is
She has a right
no,
to
but
file.
but the situation should be also considered, Lordship. That
That
they
we
are
consider
they
when
are
we are
taking
passing the final order. That can't be considered today. Take down. This is an application first. Item 1 में restoration application is GA3. This is an application for filed by petition number 4 for restoration of the writ petition.
My lord,
It
GA3
also-
and GA5, both of them are restoration applications. And
So in item 1, GA3 is restoration application. In item 2, GA4
it's for
is
condemnation.
condemnation and GA5 is for.
It's again for restoration.
Petition for restoration of the writ petition, learned counsel for the petitioner submits that the matter was dismissed on 26/2/2025 as the counsel for the petitioner was busy in another court. Full stop. He states that he could not appear before this court
আমি আছি কপিতে
when the matter was called out
আমি আছি কপিতে
due to his engagement in the other court. Full stop. The reply has been filed on behalf of the respondent number 7, in which it is pointed out that the restoration application is filed only on behalf of petitioner number 4, as it is signed by Mr. Ravi Kumar Bagaria, one of the partners of for Ravi Kumar Bagaria, Bagaria, one of the partner of petition number 4. Full stop. Petition number 4. The respondent further points out that since Mr. Bagaria is not having authorization from other petitioners, his application cannot be treated on behalf of other petitioners. Full stop. In view thereof, the restoration application is
item number 3
is allowed only on behalf of respondent number 4 for the reasons stated in the application. Full stop. The writ petition is restored to its original position qua respondent number 4. Petition number 4. Petition number 4.
My lord, if my lord is restoring that, my lord, I have some submissions to make, my lord. So far as this item number 1 is concerned, my lord will kindly care. My lord, this
अब 2 है ना GA, item 2 और item 3. ये 2 क्या है? What was GA2 which was dismissed?
my lord, GA2.
GA2
With the main writ petition?
GA2 টা
My lord, that GA2 is still pending, my lord. That was an exception to a report filed by the Tika country.
GA2 was also dismissed. See the order.
Dismissed.
GA2 টা কোন
That is the report to be set aside. So that will be restored to.
J2 of 20. My lord, that was some other application, my lord, that was filed by the respondents. That is not, I'm mistaken.
So that will be restored to.
My lord, there is GA2, my lord, there is no application for restoration, my lord.
That is along with the main petition. One for that is along.
The only application for restoration, my lord, is qua the WPO.
Sir, you have not asked for GA2 restoration.
Yeah, that's in the main petition. That is ours. GA2 application. This is. GA2 it is asked in the prayer. In the prayer. Yes, Lordship, please to consider page 9.
Page 9 of your application.
GA3 of page 9.
My lord, yes. GA2 is so.
Yes, Lord.
My,
And read and along with the application GA2, Lordship.
my lord, with regard to the restoration, my lord, now this comprises a property at 20 Ganeshchandra Avenue, which is a huge property. A number of unauthorized structures, my lord, have been made by this petitioners, my lord. A number of them. There are 8 petitioners, my lord. All of them and their subtenants under them have made a number of structures.
Yes.
So, my lord, if the writ petition today, there are 2 demolition orders, my lord. First by the KMC and, my lord, by the Municipal Building Tribunal. Both the authorities have found that there is not a single building sanction plan in respect of all those structures, my lord. So now, my lord,
Madam, you are talking about merit of the matter.
no, my lord, my submission is if it is restored qua the petitioner number 4, then only the petitioner number 4 structure, my lord, can be protected.
You will
till
see
the-
that.
my lord,
That's at the time when the argument will take place.
my lord, because it,
Mr. Banerjee,
my lord.
I am restoring it.
Yes, it's
Wow.
qua the person.
That's what that.
We'll make our arguments. That
I
this is-
recorded a submission. Still, she wants to do more submissions.
All the applications.
I
Recorded her submissions.
but then will not kindly the remaining part of was by youthful exuberance, my lord. Kindly pardon her.
क्या देखो यार?
Youthful too.
Writ petition as well as GA2 is restored to its qua petition number 4.
এটাই করে দেবো
3, 4 and 5.
এটাই করে দেবো
First is 4.
Yes, Lord. Yes.
3 and 5 is later.
Yes, Lord.
That I'm not allowing right now.
that your lordship, if your lordship
He
feels,
wants to file reply.
because restored qua 1 and restored qua 3 is good enough for me, same thing.
She said, I want to file my reply to the delay application. 164 delay.
And I'm like, kindly, my lord, permit me, my lord, to
Item 2 GA4. This is an application filed by the petitioner number 3 and 5 for condoning the delay of 164 days in filing the application for restoration of the writ petition. Learned counsel for the respondent states that he has no objection if the same is condoned. Full stop. For the reasons stated in the application and the concession made by the learned counsel for the respond number 7, right? Respond number 7.
আমরা কত রেসপন্ড নম্বর
Respond number 7. The present application is allowed. Delay is condoned. Full stop. Next,
ঠিক আছে
GA5. This is an application filed by the applicant for restoration of the writ petition, qua petition number 3 and 5. उसमें same order कर लो जो ऊपर वाला order है ना, for the reasons stated in the application and on the statement concession made by the respondent number 7 that he does not opposes the said application. The present writ petition is restored along with GA2. ठीक है? Confusion? Yeah, clarity to go. Sorry. Same. The writ petition is restored along with GA2 of 2025. ठीक? GA5.
GA2 allow করছে তো?
3 allowed, 4 allowed, 5 allowed. All allowed.
Great.
let the petition return any day, any day convenient to your lordship. Maybe next week, maybe
After vacation,
whenever convenient.
whenever you want.
Next week, let it remain next week. If my learned friend is in difficulty, he can pray for an adjournment.
No, I have no difficulty. If lordship may please to if the matter before vacation, I have no objection. I being the petitioner.
Before vacation, 25th, we can have it on 25th.
Yes.
25th.
Yes, let it
Now,
be
what
there
is
on.
the urgency?
No,
Is there-
there's actually no urgency. Urgency should be for him, but then we'll.
And he's not interested.
Fair enough.
He
After
says,
vacation. After vacation.
he says after vacation.
After good enough.
After vacation. Keep it on
The order of one state will state out.
6th of November. List on 6th. I'm just restoring it. So original possession, you mention it whenever.
Application restore state.
I'm just restoring it to its original position. Why should I give a
He
date?
would actually want to keep it. What will happen is he'll actually once
No,
the
no,
list
with
is restored.
liberty restored to its original position. Let it
Restored
go
to
on.
its original position. Fair. না, ঠিক আছে পরে আমরা মেনশন করব ঠিক আছে চাপ
जहाँ हमने किया ना based on original position, bas that's it, nothing else. Different orders. The GAs have to be different orders. नहीं, GA3 is qua petition number 4. GA 3 and 4, one is that condonation and the other is the restoration application.
Previous occasion corporation notice already stayed by.
Lord, I just thought, Lord, if your lordship makes it returnable in the next, let's say November monthly list, at least the matter can then return. Otherwise, अच्छा, नहीं, ठीक है.
Yeah, lordship.
ठीक है.
Restore to its original position, whatever it is.
Yes.
We'll see.
Pleasure addressing your lordship, Lord, after almost a year now. The cap seems almost a year.
Lordship,
Yeah.
lordship, stay order was passed by this honorable court. That is also same order. We continue.
I have just restored it. I am not passing any other order. That's all.
One of the private response.
Then the previous occasion the stay order was.
Whatever it is, sir, I have restored it. If you have a stay, the stay will continue. I'm not making any clarification. Any problem?
If this is my application for restoration,
Nothing more.
Milord, in item 4, Milord, I am.
That is done. All three matters are done now.
Milord, in item number 4, Milord, I am.
Yes,
applying for one
what
of
is
the
there in item?
Lordship,
4?
I am the petitioner, Malad. This is my application for restoration.
For restoration, yes.
Lordship,
Milord, I have not received the copy of the. Milord, I have not.
Give a
received the
copy. You have not.
Lordship, I have given a copy, Malad. It has come back. Now my learned friend says that the name is wrong, but he's appearing today. I do
Do
not
you
know
have any
how.
objection to the restoration?
I do not have any objection to the
We'll
restoration.
I should serve them a copy, Lordship, here and now, Malad. It is
Take
not.
This is an application filed by the petitioner for restoration of the writ petition, full stop. The writ petition was dismissed for non-prosecution on 7/8/2025 as none had appeared on behalf of the petitioner, full stop. Learned counsel for the respondents. Who all are there, respondents?
I'm for 11.
There are
Milord, I am for 10.
1, 2, 3.
the Kolkata Municipal Corporation.
1 to 4, Calcutta Municipal Corporation, as well as you are who's for state?
I am appealing for the statement.
State, respond number 5 to 8,
5 to 8 minor.
and you are appearing for
Milord, I am for 10.
respond number 10,
And I am for 11.
11 states that they have no objection if the same is restored. For the reasons stated in the application and the concession made by the counsel for the respondents, the present application is allowed. Writ petition is restored to its original position.
Lordship may fix a date for hearing of the writ petition, Malad.
Original position. ये देख लेना है क्या है.
Original.
This is just 1 second, Miss Sengupta.
Yes.
This how many petitions? Where is how many petitions you have filed in this?
There are many petitions, many. I
Petitions.
can't even,
Yes.
Mr.
One
Eka.
writ petition, Malad.
No, he are not
Oh,
here.
dear,
Movement
how
at
many
the
writ
smooth
petitions you have
train.
filed?
Yes, many, Milord.
Many.
Who are you?
Lordship, I am a resident of
एक मिनट
this
पहले-
area,
Yes.
this Narkeldanga area.
So
Lordship,
you are a
this
public spirited person.
public spirited person.
How
and
many
this-
petitions you have filed earlier?
So I have filed around 3-4 petitions.
All right,
in
give the
past.
file 1 minute. Give the file.
Milord, if I may recollect.
Wait a minute, wait a minute. You file an affidavit. Let me see your bona fides.
Lordship,
No, you file an affidavit.
Lordship, I will file an affidavit. No problem.
The petitioner. Yeah. Four. Writ petition. दो.
But this particular person, several writ petition, several proceeding is pending, some in criminal case also been filed.
We will see.
No, see, criminal cases, matlab,
Na criminal case শুরু হয়েছে তো, প্রচুর।
He doesn't inspire a lot of confidence. Yes, take down. The petitioner has preferred the writ
I
petition
shall
being
also
agreed
show
by
the
the
orders passed in.
inaction of the respondent municipality in not taking any action against the unauthorized construction taking place at 6 different properties, right?
Lordship.
Mentioned in para 4 of the writ petition. Full stop. The petitioner has made respond number 9 to 12 as persons responsible for carrying out the said construction, said alleged illegal and unauthorized construction. Petitioner states that he is not sure if they are the owners of the said property. Full stop. Owners of the said property. The petitioner is directed to file an affidavit disclosing his credentials, including his qualification, profession, and his current. What are you doing currently?
Lordship, I'm running a business now.
Profession and his current business activities. Full stop. The petitioner shall also disclose the details of all previous writ petitions which he has filed for
All alleging unauthorized construction.
About the
alleging
criminal case
And
also.
against one particular person
alleging
who is doing all
unauthorized
these things. It's a
alleging unauthorized
multi-crore
construction.
scam which is happening in that area.
But,
Entire.
there is a sanction plan as well.
And the ballot
Not even
particular,
a
ballot, there
floor
are
is
five
sanctioned.
The-
criminal cases, ballot, where Narkeldanga police station, I appeared for
Yes,
the police
yes.
authority.
This Narkeldanga is also complicit
The
in all these
petitioner-
activities.
The petitioner shall also file the list of all criminal cases which he has filed
Which has
before,
been lodged against him.
which have been filed against him, list of all criminal cases which have been filed against him, along with all orders passed by the courts, passed by the High Court or the courts below, or by the subordinate courts. Full stop. जहाँ वो affidavit लिखा है ना, disclosing his writ petitions which he has filed alleging unauthorized construction, along with all orders passed by this court in those writ petitions. Full stop. List on next week.
Milord, after vacation, Milord, kindly. Because if he files an affidavit, because only one thing, Milord, he has not served me the writ petition টাই পাইনি আমি।
Writ petition দিয়ে দেবেন in time.
He keeps it after vacation.
Kindly keep it next week.
No, I need some time to prepare this.
Why? You are aware of all your cases.
I have to compile all of them and put it in an affidavit.
Kindly make it hard in part.
Yes, hardest part.
Milord, kindly direct them to file give me a copy of the writ petition.
They
Give a copy of the petition. You'll be lucky if I'm not here. So let's keep it after vacation.
Yes, I am ready to face my lord. There are lots of orders in my favor,
7th,
and that will also show the conduct of the police
list on
officers,
7th of November.
how they are part of the scam. Grateful, my lord.
I, my lord, beg to appear on behalf of the petitioner, my lord. This Malot affidavit of Elite. Yes.
কেন ওরা নেই?
What is this?
This is for my lord. Initially, my lord, I entered into a development agreement, and there is some deviation, and my lord, change of use. Corporation issued notice.
This is that which has been ordered by Justice Mantha to be demolished.
No. That is not my lord. On the contrary, my lord, I have challenged the regulation 5 of my lord, building regulation in the appellate stage, my lord. Kolkata Municipal Corporation Regulation of Building Regulation 2015, Regulation 5. And the Honorable Division Bench, my lord, has taken cognizance of it and, my lord, remanded back this matter before your lordship. Your lordship will find that order at page 35. And I shall file, my lord, amended writ petition also.
Page 30?
Page 35.
Yes.
Yes, my lord, that, my lord, I want to extend because initially, my lord, order was passed for the retention of the, my lord, unauthorized construction and, my lord, because there is a little deviation on only 97 square meter, my lord. So that was placed before the, my lord, commissioner. The commissioner placed it before the mayor and council, which was turned down and passed it, my lord, order only to, my lord, retain the, my lord, unauthorized construction, my lord. That, my lord, action I have challenged before the writ court. Writ court also, my lord, affirmed the decision of the mayor and council. Against that, my lord, I preferred this appeal, intra-court appeal, in which, my lord, I have challenged the regulation 5. So, my lord, my humble submission before your lordship today is only, my lord, extend the interim order, not to demolish the structure. In the meantime, I shall file, my lord, my amended writ petition, incorporating that, my lord, virus, challenging of the virus of, my lord, Rule 5.
No, but what do you mean extend? Is there a stay already granted?
Yes, my lord. It was up to 31st May 2025.
31st May.
Yes. In the appeal court order, my lord, page 36. Second last para, my lord. Substituting the interim order passed in the appeal with regard to status quo regarding the demolition will continue till May 31st, 2025.
But that is subject to the single bench,
Decision.
right? Yes, Mr. Ghosh.
So whatever the facts has been stated up to the order of the division bench, I agree with that, that is the fact, my lord. But the thing I submit to your lordship, my lord, that you also kindly seize the order which has been, of course, set aside by the honorable division bench, which is at page, my lord, 20. It was at the stage, my lord, that under the regulations that he was required to go before the authority for further hearing in the matter. That was told. All that I'm submitting to your lordship, my lord. Your lordship may be pleased to, my lord, stay the demolition, because demolition is not taking place right now, because you are asked to appear before the authority for hearing. But if the hearing takes place and order is passed, my lord, the demolition order, that your lordship may protect him because of pendence of the writ petition. But so far as the participant in the hearing, because if the order may go in his favor, I do not know. Because that is the reason, my lord, in terms of the regulation, it is forwarded. He says that it cannot be sent to the mayor and council. But the regulation says that in case of, my lord, allowing detention, while calculating that it is to be sent. Now he is questioning that it cannot be sent.
That is all merit of the matter. Today we are only looking at the stay which is asking for. So you don't have any objection to the stay?
But I'm not the only, my lord, if your lordship thinks of variation to the extent that a participant may be made, and whatever the order, that shall be subject to your lordship's decision. But either way, it cannot be given effect to.
No, I didn't follow you. What?
He was asked to appear for a participant in the hearing.
Yes.
He's asking for that it cannot be done. That is the issue. All that I'm submitting, he may participate, then whatever the decision may be taken by the authorities,
Yes.
that may not be given effect to or subject to decision of this appeal, writ petition. Therefore, either way, the order which it cannot be given an effect to, either in his favor or, my lord, against. It cannot be given an effect to, but the process may be completed. Then you will decide the issue.
That
The
will
process may
not
be
amount to
completed.
reopen
The process
this
may not-
issue.
But after that, if the process is completed,
Reopen this
what,
issue.
what protection he is asking for, he is protected. But only in submitting that.
So we'll record your submission that he is protected. You're not giving effect to
No,
the
no,
order.
I am protecting in the sense I'm submitting, my lord. If your lordship passes an order, not to give effect to that order, either way, whatever the way order passed, then it will be helpful to have. If your lordship thinks that it will not be permitted right now, then it's all right. I cannot say anything, my lord.
Because that will, my lord, reopen the issue again, my lord. Already, my lord, special officer decided this thing, my lord.
Yes.
And, my lord, it is only placed for approval, my lord.
Yes.
For, my lord, calculating the charges for the retention fees, my lord. In that proceeding, my lord, altered that decision. Well, that is, my lord, request some hearing, my lord, whether that power is there or not in the mayor's council.
Well, the regulation speaks for that after the decision is taken for detention.
That's why, my lord, I have challenged the
He
section.
is challenging. Before calculation, matter
Regulation
shall
5.
be sent to the mayor and council.
Today you have not done that. You have not amended the writ petition.
Sorry, my lord.
Should have amended.
Within a week, I shall file, my lord. Within a week, my lord. Within a week, I shall file.
You are only interested in this stay, nothing more.
My lord, within a week, I shall file, my lord. Because it requests, my lord, further affirmation also required.
So you file your amended writ petition. In the meantime, I'll record that corporation is not taking any action. Let him file his amended writ petition. Take down. The present application has been filed by the petitioner seeking interim order staying the operation of the demolition order dated 18/4/2023 passed by the special officer building in terms of the direction of the Honorable Division Bench in APO number 125 of 2024, until disposal of the present writ petition. The matter arises out of remand, full stop, wide order dated 6th February. This 6th February order, right?
My lord.
This
6th
February,
Feb, yes.
6th February, right? 6th February 2025. This.
Initial date of.
When was the first order of?
My lord, that
stay?
is, my lord, at page 28. Passed by the division bench, page 20.
First stay granted to you on
23rd September 2024.
23rd by order dated 23rd September.
Yes.
Where is that page?
Page 28.
I was sitting in division bench.
Yes, my lord. Sorry, my lord.
Should have pointed this out. I have passed an order in the
Yes,
division
yes, my
bench.
lord.
I can't.
Kindly release this.
You should have pointed this out.
Sorry, my lord. I'm extremely sorry, my lord.
Take down. Let this matter be listed. Since yes, release. The present writ petition is, let the present writ petition be listed before another court. Since the same matter was listed before me in the division bench. Full stop. Let it be listed before another bench, subject to orders of the Honorable Chief Justice.
My lord, kindly excuse me, my lord. Excuse me.
Should have told.
I'm for the petitioner, Lordship. My senior learned advocate on recording this matter is suffering from health issues, so he won't be able to appear before this learned court. Today I'm praying for, not today.
What is? Not today.
You also asked them, my lord, to file exception, if any, my lord, that was within the particular
You want to
time.
file your exception to the report filed by the corporation?
I have not yet received anything.
Any
I
exception?
got this, anything, so I'm not sure.
Mr. Ghosh, I don't think so. She's in a position to help you.
Milord,
Lord, I'm appearing for the
petitioner.
respondent number 7.
Milord, I am Milord praying for Milord not this week because Milord advocate on record on behalf of the petitioner Milord is father Milord is seriously ill and hospitalized Milord. His Milord could not Milord able to come and Milord the council.
Matter come up after vacation, my lord.
Milord, I am praying only for the not this week Lord.
At the request of the parties, let this matter be adjourned. ऐसे कर देना. Learned counsel, learned proxy counsel so and so appears and states that the main arguing counsel.
I am for the corporation.
Corporation. I am for
Is
private.
indisposed and prays for an adjournment. Let this matter be listed after.
আমি লিখে দিচ্ছি নিষেধ যাবে
But item number 8 is my application, but I am praying for the writ petitioner. I have also taken out an application GA1. Now, my lord, the petitioner has filed this writ petition before this honorable court for implementation. Sir, please.
You will not allow me to make my.
No, my writ petition, my GA1 is there. My GA1 is there. But I need to apprise.
You expect that I will not say anything?
No, of course I will.
Your junior, he briefs you. So today he will speak. Yes.
Yes. But this writ petition was filed by my client for implementation of an order passed by the special officer building. While this writ petition was being taken up, my learned senior friend's client had also filed a writ petition challenging the order passed by the special officer building. Now, my lord, both the writ petitions was taken up by the both the writ petitions were taken up by the honorable coordinate bench, and my lord, it was being both the writ petitions were being heard together. Then, my lord, the parties, my client is the my lord landlord, and Mr. Ghosh's client is the tenant. Now, my lord, we had come to an agreement when the matter was being heard before the honorable coordinate bench. Now, my lord, it is with regard to his shop room where from his tenanted shop room where from he was carrying on his business. I am the landlord. Now, my lord, there is a sanction plan. I had to make my construction. Now, my lord, since he was at that point of time not cooperating, that is why I had to approach this honorable court, and the writ petition was being heard. And my lord, we came to a particular agreement during the writ petition was being heard that we will provide him with a temporary shop room. He will hand over possession of his original shop room to me. I will make the construction, and after the construction is being done, my lord, I will hand over him the possession of his newly constructed shop room, and he will give me back my temporary shop room. Now, my lord, this was done. Now, my lord, there were 3 orders, agreed orders passed by the Honorable Coordinate Court. Now, my lord, in course of the hearing of the Honorable the matters, the Honorable Court directed the parties to be present at the site, make measurements, and I was to show him where is this newly constructed shop room was to be there. We were directed to be present with our engineers. We have done that. Everything is done. Now, my lord, after the orders were passed, he had handed over me the original shop room, and I had given him the temporary accommodation. Thereafter, I constructed the newly constructed shop room. Thereafter, my lord, he had taken out an application for contempt alleging violation of all the 3 orders. Now, my lord, in course of hearing of the contempt application, he said that there are certain issues. The Honorable Contempt Court directed, my lord, the parties to make an inspection in the presence of the engineers and also the learned advocates on record. That was also done. The Honorable Contempt Court was satisfied that yes, the order has been substantially complied with. Thereafter, my lord, I said to him that my construction of the new shop room is complete. You please take possession of the shop room and hand over me the temporary, the rehabilitated area to me. That has to be done in tandem. He has to hand over to me, and I'll give him possession of that. Now, my lord, he is not willing to do that. He has, my lord, I have taken out an application being GA1, and at the time of the hearing of the contempt application also before the Honorable Contempt Court, I requested him that because my business is suffering, because that the temporary shop room which I have given him, from which he is running now business, my lord, was the shop room from where I used to run my shop. I used to run my business. So, my lord, I was suffering. Now, my lord, he is not complying with the further directions, that not handing over me the possession of the temporary shop room and not taking the possession of his newly constructed shop room. On that premises, my lord, I had taken out a GA1, which is pending before Lordship's Court. My lord, this GA1 was served upon him. I mentioned the GA1 for inclusion in your Lordship's list, my lord, on 15th May, then on 23rd June, and on 11th August. On 3 days, I mentioned, as your Lordship's practices, you hand over the slip, I'll see the urgency and direct the matter to enlisted. Now, my lord, somehow that matter is not enlisted, but probably it is there in your Lordship's file. My lord, if your Lordship kindly takes up my GA1, if your Lordship wants to, my lord, go through the orders, I need to place them. And the content orders, everything is there. My lord, in his application, I would say, my lord, he has suppressed all these things. My GA1 is there. If your Lordship kindly takes up. But GA1, I should say my GA1 is not appearing in the list. But if your Lordship directs, I can place GA1.
Yes,
What is the prayer? What he has paid for in the GA1, I am also making the same prayer before your Lordship, because he declared the shop room which will be handed over to me, he has started running the business.
No, very good.
Taking the approval from the bench. Well, he has started. Therefore, you also can see, well, what is the prayer? Only I am submitting, my lord, it should be ensured that the construction has been made in terms of the sanction of building plan. What is the, you also can see my prayer to hand over. Whatever the construction, I am not going into further dispute the matter.
He is ready to hand over.
It is ready to hand over.
No, that is the prayer. Not
that is also.
GA also is like that. He's also like that.
Yes,
Only
sir.
I am submitting to your Lordship, my lord. Let him hand it over. My client, my lord, has written a letter, because the length and breadth of all these things are there. I'm not going into all these with my lord. Whatever the construction made, the honorable single bench, my lord, he has reported. Your Lordship can see, my lord, these are the points might be considered by your Lordship. Whatever the way your Lordship consider, my lord, consider and pass an order for disposal of both the requisition. Your Lordship kindly come to page, my lord, the letter which has been written to my London advocate on record by the client, that it may be brought to the knowledge of the consideration of the authorities. You also can see that page, 51. My client will go to the permanent accommodation. What about the consideration he has made? Logically, see, my lord, page 51. Some of the points I have mentioned. It should be ensured with the certificate of the Kolkata Municipal Corporation that the newly constructed shop room has been constructed in accordance with the sanctioned building plan. Because I am to go there, because it should be ascertained that it is in terms of the sanctioned building plan. In order to facilitate the running of the business, the Said Arvind Kumar Shah should ensure that compliance with clause C of the schedule of the property as mentioned in the agreement of no objection. What are the facilities to be provided? Today, my lord, simply he is handing over the shop room and without providing the facilities which have been enjoyed, and he agreed on terms that should be, my lord, complied with. It is on agreement for no objection document. I may, my lord, place that agreement for no objection. Therefore, my lord, it should be complied with by him. Second, my lord, since the meat shop is run with an intermediate platform between the floor and the roof of the shop, then the newly constructed shop room, after taking possession thereof, is found to be not conducive in running the said business. Mohammed Nasir may be permitted to make some alteration of the construction work inside the shop room without any interference or objection from the industry or petitioner. Because of the intermediate, you know, to run the meat shop a lot, and intermediate platform is
So
there.
why don't I refer you to mediation? Go and settle it before the.
Malad, may I say one thing?
Well, I may go,
Malad, the
that-
conditions.
because well, these are the
Malad,
things.
may I say
these
this
are
thing,
the
Malad?
things, well,
May I-
if
may-
you does
may I
not
say-
do
may I
that,
say this thing?
Then I
Lordship-
will put into jeopardy.
Lordship
Let's
kindly
go.
takes up page 46. This is the communication from the tenant to his client advocate. Well, whether this communication could be made a part of this application is, make my submission later on. My lord has seen the conditions. Lordship will kindly
I'm
see
not-
the last. Lordship
Yes,
kindly.
but consideration
My
of
lord,
the
this,
order, yes.
Lordship kindly sees the last condition.
If you want settlement to this.
But let him take it as it is, because I have.
Then you will be.
Then, my lord, these are my
Then you have to be-
these are my rights.
object.
My lord, no. These are my rights protected under the Civil Act. But I have that act. But West Bengal Premises Tenancy Act, I have brought it for this reason. West Bengal Premises Tenancy Act gives me the protection of whatever conditions are here. Lordship will kindly see the last condition at my lord, page 51. Last condition G. Since Muhammad Nasir has been grown old and has been suffering from the defined ailments, this honorable court may be pleased to ask Mr. Arup Kumar Shah, that is my client, to transfer the tenancy in favor of his son Abu Shama, provided Sri Arup Shah does not agree to outright sell or sale of the newly constructed shop room in favor of either Muhammad Nasir or his son Abu Shama. So he wants to purchase the property. I am not agreeable to sell the property. So he will approach the honorable writ court for a direction for my client to sell off my property to him.
I'm not asking any direction. I'm
Then,
just.
my lord,
giving
that is
consideration. I'm not asking that this is my condition. I'm not.
and my lord,
doing
the
that.
other
In
things,
any way.
my lord, may I say, this is absolutely, my lord, the last
What do you want in a writ court?
But I do not want it. I say you hand over me the temporary shop room and take your position of your shop room. That's the only period.
We'll hear it later.
But I have repeatedly asked
Kind
him.
of, we are not sitting here as a.
No, not that. My lord, I have asked him repeatedly.
This
You can
court is
take
not a
this.
panchayat court.
No,
You have a
if-
legal point
I
to argue.
am not
you
arguing
argue.
anything, but I am not arguing. Let him
I'm
take
the last court who does panchayati.
But this Saturday, let them come and let us, my lord,
You
exchange
want,
the
I can
shop.
refer you to mediation. I don't believe in mediation here in this
No,
court.
I am not on mediation.
I'm not going to waste the time of this court.
My lord, kindly
There are
sense
much better things to do.
My lord, kindly sense that.
At the request of the parties, to explore possibilities of an amicable settlement, let this matter be referred to the mediation cell here. What is it?
My lord.
Mediation center. Mediation center.
And you receive my
With
lord.
liberty to the parties to mention in case no amicable settlement is arrived at, the parties are at liberty to mention.
You should place it there immediate after the vacation. In the meantime, whatever the time after you lost it.
I've given you liberty, Mr. Ghosh, to mention it. If the mediation fails, you mention it, it will be listed.
And even the mediation ballot is successful ballot, so far as their terms and conditions,
can mention
then it is to be placed before the
That's what I'm saying. So you can always mention it. Either ways you can mention
No,
it.
if the mediation fails or if the mediation is successful, either way, the petition have to be disposed of by your lordships. That's all.
Absolutely.
Yes.
It is just that we'll make the agreement a part of the.
Yes, the part of the petition, both the petition can be disposed of along with the GA please. That's all.
Here also maybe please to give a time with the request to the mediator so that it could be because there is some urgency in the matter. Just there is the reason. But my business is also suffering.
Time period for mediation. Generally,
request
there's a
it.
time.
I
Generally,
not
there's a
get
time period.
To
Mr. Ghosh, there's always a time period in mediation. The mediator, let it leave it to the wisdom of the mediator.
But 8 and 9, same.
Same.
Grateful to your lordships, court, madam.
The last occasion, my lord, your
Last occasion
one
also,
matter is non-prosecuted, and this matter your lordship directed. I need some more time. I have the report, but I cannot place before your lordship regarding the issue. The petitioner is not coming on the last occasion also.
take down. None appears for the petitioner. Even on the last date, i.e. 31st July 2025, there was no appearance on behalf of the petitioner. Full stop. It seems the petitioner is not interested in pursuing the presented petition. The same is dismissed in default.
Grateful. Hey.
All of that. Kindly, my lord, take it. I missed the matter, my lord. It's my fault. It's a dispute relating to, my lord, a lawyer's
Chamber.
Yes. Kindly take it up next week, any day, my lord, convenient to the court.
Next week. Or after vacation.
After vacation.
Whenever you want.
After vacation, my lord, in that event, lordship will understand, my lord, why.
All right. At the request of the parties, let this matter be listed. Mr. Mitro, after vacation, right? Let it be listed. You want a date or I'll just say after
Just after
vacation?
vacation.
After vacation.
What are you hearing about technique?
I am obliged. Any question?
14, my lord, I am for
I'm
the
for the
petition.
respondent, my lord.
My lord has my lord had the occasion to hear the matter. Where is that matter, my lord, wherein I had, my lord, purchased a property out of an auction sale, and my lord, everything is completed, my lord. Even the auction purchase property is handed over to me now. One fine morning, the KMC has nudged up from the sleep, and my lord
What is
saying,
left now?
my lord,
What is left?
my lord, now they.
It is money payment to me for the purpose of mutation.
My lord, I am the, my lord, lordship has, my lord, then my lord, after hearing the parties, my lord directed the affidavits to be exchanged. The affidavit affidavits are all filed.
Proceedings are complete.
So let's argue.
My their opposition, I believe, is
Lord, let them, sir.
my lord,
I'm ready with the matter.
Let's start.
my lord, ঠিক আছে.
I handed up to your lordship two judgments. One is
The-
of KC Ninan, another is of our Chief Justice. My lord would kindly keep
Yes.
that in hand.
Do you have another copy?
I have got. I can hand up.
When the
But
judge,
the thing is, my lord,
we had cited, we had also given the copy.
but I have to take it back.
My lord, the
Only caveat. I have to
No, no.
take it.
Yes. I have it in my chamber. So I'll
my lord, to start with the short backdrop, my lord, once again, my lord, we had filed the Section 7 application. An application was filed in under Section 7 before the NCLT, National Company Law Tribunal, wherein, my lord, at the stage of the company to be gone into liquidation, my lord, the properties, my lord, were put to auction of the company, and my lord, it is basically a leasehold property.
Today, what is your grievance limited to?
Yes, yes, I am, my lord.
No. What is the grievance? What are you seeking?
My lord,
Yes. No, Mr. Carr, please.
But the grievance is that, Lord, we are not liable to pay the area taxes.
Area.
That's
After
from
completion
the
of
date of handing over a possession, we are liable.
All
But-
right. Let's hear you. Come, Mr. Carr.
Sorry.
তুমি বলছো কেন আমাদেরকে
List of dates.
হ্যাঁ লিস্ট অফ ডেটস কপি
Lord, does your lordship have a copy of a list of dates, Lord?
we had handed over.
Yes.
This will give your lordship, Lord, background. Lord, there used to be a company called Enfield Apparels Limited.
Yes. Yes.
So this company was having possession of 4 million industrial units. Now, pursuant to an application filed under Section 7 of the IBC, Lord, this company went into liquidation. Now, Lord, your lordships will see the first date is the date when an application under Section 7 was filed against this company, Enfield Apparels Limited. Then, Lord, this was admitted, Section 7 was admitted, Lord, on 6th August 2018. Then 4th April 2019, Lord, a liquidator was appointed in respect of the company in liquidation. Then, Lord, the liquidator, Lord, prepared a list of stakeholders on 20th May 2019.
Yes.
Which did not show KMC had filed its claim on account of outstanding property tax before the liquidator. Then May 2019, the petitioners came across a e-auction sale notice in Business Standard and Ajkal, wherefrom the petitioners came to learn that certain assets of Enfield Apparels Limited were being e-auctioned by its liquidator, Mr. Kanchan Doctor. Then invitation for expression of interest for acquisition of assets of Enfield Apparels Limited, liquidator issued, liquidation issued by the liquidator. The expression of interest contained a clear declaration the assets of the company's debtors are being sold as is, where is, whatever there is, and without recourse basis. And as such, sale deposition is without any kind of warranties and indemnities. Then, Lord, it says in an application so and so filed by the petitioner number 1 before NCLT Kolkata inter alia seeking setting aside of the sale, because, Lord, we were not given an opportunity to participate. We filed an application for setting aside of the sale, and the sale was subsequently set aside. Your lordships will kindly come to the next date, 12th March 2020, when, Lord, the learned NCLT was pleased to cancel and set aside the earlier e-auction. And the sale was confirmed in favor of the petitioner number 1 at a total bid of 15.50. Then, Lord, 13th October, on an application made by liquidator, the learned NCLT permitted the petitioner number 1 to 5 to jointly complete the transaction. Then, Lord, 19th January 2022, possession of the subject property was handed over to the petition. We admit, Lord, from this date, we are liable to pay the municipal taxes. Then 7th May 2022, by 4 separate deeds of assignment, all executed on 7th May 2022, the subject leasehold factory units were transferred in favor of the petitioner number 1 to 5. And then, Lord, the company was dissolved in terms of Section 54. And ultimately, Lord, we applied, Lord, for mutation on 29th August 2024. And, Lord, this is the demand that the municipality raised, which is, Lord, our cause of action in the instant writ petition. Now, Lord, if your lordships, Lord, kindly seize the expression of interest first. I start with the expression of interest. It is at page 51. Starts from 41, 39. I'm sorry, it starts at page 39, but your lordships can kindly straight away come to page 41.
Yes.
Lord, if my lord has already marked the clause, because when we moved
Yes,
it,
I did.
So that is the clause.
As is, where is basis, whatever.
Yes. And as is whatever as is.
Whatever there is and without recourse.
Without recourse basis. And as such, sale as disposition is without any kind of warranties and indemnities. Then, Lord, your lordships may also please come to page 45. Clause 6.2.3. The shortlisted applicants may note that the information memorandum is not an all-inclusive single-window source of information relating to sale of assets, as is provided solely for the guidance of the applicant. Information memorandum is a compiled document and may contain such information which may or may not have been independently verified by the liquidator. Hence, applicants are advised to satisfy themselves in all respects independently before submitting their bids in the e-auction. But I'm showing these clauses because my learned friends are going to rely on this, therefore. But please come to page 48. Clause 7, terms and conditions of proposed sale.
Yes.
Lot 7.1.1 again says that the proposed sales will be conducted as is, where is, whatever there is basis, and without recourse basis. Then lot 7.1.3, the applicant should thoroughly satisfy itself about the nature, condition, and quality of the sale assets. The liquidator gives no guarantee or warranty as to the title of the sale assets on conditions of the assessment. These are relating to sale assets. Then lot 7.14, it shall be presumed that all the facts were taken into account by the applicant while submitting its bid, even if the applicant chooses not to inspect or conduct due diligence of the sale assets, it shall be presumed, etc. These are all 7.13 and 7.14. These are all on the sale assets. Then lot 7.1.10. The reserve price for the sale of assets of the company is exclusive of all taxes, levies, duties, or any registration fee or any other fees, charges, not encumbrances. Then please come to clause 7.1.12. The purchaser shall bear and pay the applicable stamp duties, registration fees, and all fees and expenses payable for registration of documents. This is for registration of documents. So, these are broadly the terms. These are broadly the terms. Now, if I may take your lordships to the sale notice once. 851. Over any other provisions? 9.9. Yes. Just one clause I missed out. In the disclaimer clause, clause 9.
Yes.
Please come to 9.4.
Yes.
The information contained in the invitation is substantially based on estimated information, opinions, and information collected should be from stakeholders, public domain, and independent third party. The invitation does not amount to recommendation either expressly or by implication with respect to the company or other entities mentioned in the invitation, except where specifically mentioned otherwise. The liquidator has not independently verified such information, and the same is being provided by the liquidator for information purpose only. The liquidator does not make any representation or warranty as to the accuracy, reliability, or completeness of such information, and does not assume any undertaking to supplement such information as further information becomes available or in the light of changing circumstances. Liquidator shall not have any liability under any law, statute, rules, or regulation for any representation or warranties expressly or implied contained in or any omission from this invitation or any other written or oral communication transmitted to the recipient in the course of its evaluation of the proposed financing or otherwise. Now, with these disclaimer, and 9.5 and 9.9 may also be taken note of. Nine 9.5 is with regard to the information contained in the invitation has been prepared to assist the interested applicants in making their own evaluation for the purpose of submission of bid. 9.5 and 9.9 may also be taken note of. Now, the sale notice, your lordships have taken note of, this covers the sale notice also. Then Lord, your lordships may kindly.
You had also read out 9.7 last time.
Yes.
No claim, in between, no claim shall lie against the liquidator with respect to the content of
Yes,
the
yes. Yes. Lord, I will, when I show your lordship the provisions of IBC, your lordship will see that, Lord, the sale is on the basis of a clean slate. Therefore, Lord, liquidator takes no responsibility.
Right.
Number one, and insofar as the sale conditions are concerned, Lord, sale conditions clearly says that this is as is where is, whatever there is, and without prejudice basis. That condition is inbuilt, and there are elaborations of that conditions in various clauses. The liquidator does not take any responsibility with regard to the sale conditions. I mean, anything which is left out in the sale conditions. Now, Lord, in so far as the NCLT order is concerned, which is not at page 57, it starts. Please come to page 68.
Para 18.
Yes, para 18. Your lordship has already marked it. I must have placed it when I moved on. Then, Lord, the possession, which is at page 124. After this, Lord, our offer was accepted, and Lord, possession was handed over at page 124. Possession certificate is at page 120. (124) the possession certificate. Then, based on that, Lord, we approached Lord WBIDC, who's the original lessor in respect of these four industrial units. Then, Lord, there is a deed of assignment, 4 deed of assignments which are executed in our favor. These are not. I'll give your lordships the date. I can just show your lordships one document which is at page 71.
70?
71. 71.
Yes.
But your lordships may kindly see at page 78 the Havendum clause.
Yes.
Lord, the Havendum clause at page 78, and Lord, the schedule which is at page it starts at page 114 at 115. This is module number A202. There are 4 modules, Lord. This is one of them. 1050 square meter. Now, Lord, while at this assignment, the lordships may kindly see that this is a document which was executed between West Bengal Industrial Development Corporation, Enfield Apparels. At page 71, my lord will see this is a tripartite document. This is signed by West Bengal Industrial Development Corporation Limited, the lessor. Then, Lord, page 72, Enfield Apparels. Lord, this is the company in liquidation, signed by the liquidator. And, Lord, Cotton Casuals is the purchaser. Now, if your lordships, Lord, kindly sees clause 6.2, which is at page 87. Outgoings. Has your lordship found that? Outgoings.
Yes.
The transferee sublessee shall pay, discharge and satisfy all land revenues, municipal rates and taxes, duties, assessment, outgoings and imposition in respect of the demise module payable to any authority of the government or any other appropriate authority or otherwise, which during the tenure of the present sublease be payable, imposed or assessed on the said demise module, whether payable by the owner, sublessor or the demise. And note, it also says the transferee sublessee shall also be liable to pay any dues, areas outstanding and due, if any, payable to any authority for the period of the present sublease, enjoyed by the transferee sublessee during the period of possession and present sublease. So, Lord, this document was executed in May 2022. But as I said, Lord, possession was prior. We came into possession of the property prior. Now, Lord, these are the basic facts insofar as this company is concerned. May I just show your lordship, Lord, one or two provisions of the IBC, and then, Lord, I show your lordship the judgment. Section 33, Lord. Talks about initiation of liquidation. Lord, 34 is the appointment of liquidator. Then Lord, 35 power of the liquidator. Then Lord, 36 is the liquidation estate. Lord, if I may just place 36, it says, for the purpose of liquidation, the liquidator shall form an estate of the assets mentioned in subsection 3, which will be called the liquidation estate in relation to corporate debtor. Then the liquidator shall hold the liquidation estate as a fiduciary for the benefit of all creditors. Subject to subsection 4, the liquidation estate shall comprise of all liquidation estate assets, which shall include the following. Then Lord, whatever the assets, tangible, intangible, whatever the assets are, that is included. Then Lord, the sale section ta koto? Sale section. Regulation 32 ওটা সেল এখানে হবে এটা আগে 53 তে দেখিয়ে দিলাম section. Then please come to section 53. Lord, it is notwithstanding anything to the contrary contained in any law enacted by the parliament or any state legislature for the time being in force, the proceeds from the sale of the liquidation assets shall be distributed in the following order of priority and within such period and in such manner as may be specified, namely, then insolvency resolution process costs, the following dates which shall rank equally between amongst the following: workmen's dues, dates owed to a secured creditor, then wages and unpaid dues owed to the employees, then financial dates owed to the unsecured creditor, then following dues shall rank equally between and the amount following. It says any amount due to central government or the state government, including amount to be received on account of consolidated fund, etc. Dates owed to a secured creditor for any amount unpaid following the security interest, any remaining debts, preference shareholders, if any, equity shareholders. So, Lord, whatever the assets which are money which are received by sale process, this is the distribution of assets, and it has an overriding effect, notwithstanding anything to the contrary contained in any law enacted. Huh? And Lord, my learned friend wants me to point out that KMC will come under F, any remaining debts and dues. Sale power to the 54. Section 238. And Lord, section 238, if your lordships kindly take note of, that has an overriding effect. the Lordship will find from section 238, it says the provisions of this code shall have effect, notwithstanding anything inconsistent therewith contained in any other law, for the time being in force or any instrument having effect by virtue of any such law. So, Lord, effectively, this will override, Lord, the Kolkata Municipal Corporation Act, provisions of the Kolkata Municipal Corporation Act. Regulation. Lord, there is an regulation. It says liquidation process regulation 2016. I'll just assist your Lordship, Lord, with that. Which governs, Lord, the same. The regulations must be, Lord, just after that.
Which regulation you're talking about?
Insolvency and Bankruptcy Board of India liquidation process.
Yes.
Regulation 2016.
Yes. Yes.
Kindly come to chapter 6. Regulation 32.
Insolvency resolution process cost. That's chapter 9.
Lord, sorry. Chapter 6.
Chapter 6.
Yes, Lord. Chapter 6, it says realization of assets of 2016. May I hand up, Lord? It starts with regulation 32. Lord, says sale of assets, etc. Liquidator may sell. I'm sorry.
Yes. Yeah. You can. Yes.
Lord, if your Lordships kindly take 32 first, regulation 32 says sale of assets, etc. The liquidator may sell an asset on standalone basis, the assets in a slump sale, set of assets collectively, etc. Provided that where an asset is subject to scrutiny, security interest, it shall not be sold under any of the clauses A to F unless security interest therein has been relinquished to the liquidation estate. Then, Lord, please come to 33. 33 says the liquidator shall ordinarily sell the assets of the corporate debtor through an auction in the manner specified in Schedule 1. Has your Lordship got that? Regulation 33. And Schedule 1 is, Lord, your Lordships will find it gives a model, no, Schedule 1, yes. It says mode of sale, which is, Lord, after Regulation 47A, your Lordships will find. Lord, this is, Lord, the guideline for the liquidator to follow. After Regulation 47A, your Lordships will find the Schedule 1.
Yes.
This says that where an asset is to be sold through auction, liquidator shall do so in the manner specified herein. Liquidator shall prepare a marketing strategy with the help of marketing professional for sale of assets. The strategy may include releasing advertisement, preparing information sheet, etc., etc. And these are the procedure that he has to follow.
Yes.
Then, Lord, please come back to regulation 33, sorry, 34. 34. Regulation 34, which says asset memorandum. On framing the liquidation estate under section 36, the liquidator shall prepare an asset memorandum in accordance with this regulation within 75 days from the liquidation commencement date. The asset memorandum shall provide the following details in respect of the assets which are intended to be realized by way of sale. Please come to F. Any other information that may be relevant for the sale of assets. Now, Lord, once this sale is confirmed, then Lord, the corporate debtor gets dissolved. That is under section 54. Your Lordship will kindly take note of that. The final dissolution order is under section 54. So this is the scheme under which, Lord, the insolvency proceedings takes place. Once the company goes into liquidation, this is the procedure that is followed for the purpose of sale of assets. Now, Lord, the question is that whether, Lord, this liability, the past liability till the date of confirmation of sale and handing over of possession, Lord, is the liability of the purchaser. This is, Lord, is the issue. Lord, this has been, Lord, addressed many a times, but I just wanted to show your Lordships a few judgments on this. First, AI Chabdani, have you made a compilation? The this is 2009 volume 4 ACC. I think I had handed up, Lord, 486. 2009 volume 4. It's here in your Lordship's brief. 4 SCC 486.
Before we get into the judgments, can I just come back in 5 minutes?
Yes, yes, of course, of course.
I'll just.
Lord, may I please that judgment, Lord, Shabdani
Shabda.
Industries, yes, 2009, volume 4 SCC.
Yes.
Lord, kindly take paragraph 2 first. Your Lordship will get the facts from here. Woolcombers of India Limited, the company went into liquidation. The appellant purchased assets of the company in liquidation in a court sale for a consolidated sum of rupees such and such. Sale was confirmed by the learned company judge by an order dated such and such. The appellant was served with a notice dated 15th of February 2007 by Bhatpada municipality claiming payment of arrears of property tax amounting to rupees such and such. Now, Lord, your Lordships may kindly come to paragraph 9.
Yes.
Indisputably, the manner in which the claim of a creditor in respect of the dues of the company in liquidation is to be realized has been laid down in section 529 and 529A of the Companies Act 1956. This is corresponding to section 53 below which I placed. Dues in relation to municipal tax in terms of the provisions of the said act do not create any encumbrance on the property. It does not create any charge. It considered to be a personal liability on the aforementioned premises. We have to construe the terms and condition of sale. It reads as under. The sale will be held as per inventory made by the valuer on as is, where is, and whatever there is basis, and subject to confirmation by the Honorable High Court at Calcutta. The official liquidator shall not provide any guarantee or warranty as to the quality, quantity, or specification of the asset sold. Then, Lord, please come to paragraph 11. Both the learned single judge and the division bench of the High Court held that having regard to the fact that an inventory was made on as is, where is, and whatever there is basis, and furthermore, in view of the fact that a duty was cast upon the offerers to satisfy themselves in regard to the physical inspection of the assets, properties as to title, encumbrance, area, boundary, measurement, description, etc. of the assets of the company in liquidation, and the purchaser would be deemed to be offering his prices, therefore, with full knowledge as to the defects contained in the description, quality, or quantity of the asset sold. The appellant was bound to make an investigation in regard to the liability of the company in liquidation. Then, Lord, your Lordships may kindly come to paragraph 14. If the property tax was merely a statutory due without creating any encumbrance on the property, which had cast a duty upon all the auction purchasers to make an investigation, it would mean that they must try to find out all the liabilities of the company in liquidation in their entirety. The respondent municipality was an unsecured creditor. In that capacity, it cannot stand on a higher footing than an ordinary unsecured creditor, who is required to stand in queue with all others similarly situated for the purposes of realization of their dues from the sale proceeds. The Companies Act or any other law does not impose any additional obligation upon the purchaser to make an inquiry with regard to the liabilities of the companies other than those which would impede their value. Then, Lord, please come to paragraph 23. The advertisement did not specify that all the public charges have to be paid. The municipal corporation indisputably is not a preferential creditor. The Companies Act in relation to winding up of proceedings is otherwise a special law. While distributing the assets between the creditors and unsecured creditors, the provisions of section 529 and 530 must be complied with. All claims against the companies are required to be filed before the liquidator until the property was sold as provided for under section 457 of the Companies Act. In terms of section 456 thereof, once an order for winding up is made, the liquidator has to take into custody the property's effects and actionable claims to which the company is or appears to be entitled. Section 528 provides that all debts payable on a contingency and on claims against the company, present or future, are admissible to prove against the company. Section 529 provides for the same rule as in force for the time being under the law of insolvency with respect to the estate of persons adjudged insolvent. Section 530 provides for certain priorities to secured creditors and other unsecured creditors. Now, Lord, just pausing here for a moment, identical provisions are there under the Companies Act 2013, and they are also inbuilt in the IBC. If your lordships kindly 2013 Act first. Lordship kindly takes 2013 Act. I'll give it to you. Please come to section 290. Kindly, my lord, see, it says subject to directions by the tribunal, if any, in this regard, the company liquidator in a winding up of a company by tribunal shall have the power. Then, my lord, please take G. To invite and settle claim of creditors, employees, or any other claimant and distribute the sale proceeds in accordance with the priorities established under the Act. And Lord, 292 also, it says exercise and control of the company liquidator's power. Lord, this is of course not relevant for our purpose. And Lord, now your lordships may also have a look at this regulation. This is Lord, Insolvency and Bankruptcy Board of India Voluntary Liquidation Process Regulation 2017. Your lordship had looked into 2016. I'll just not hand up. Same, just after that 2016 regulation, Lord, it is there. Page 2017. Huh? Oh, 16, sorry, 16, it's 16, same regulation. This is voluntary regulation, no. Kindly, my lord, see.
17 or 16?
16, Lord, I stand corrected. I made a wrong mention.
Yes.
16, Lord. Kindly give him 1 minute, Lord. I just lost the page. Please come to first, Lord, definition, section 2, subsection K. It defines stakeholders. Has your lordship found that? Stakeholders means the stakeholders entitled to distribution of proceeds under section 53. 53, my lord, I have already placed. Section regulation. And Lord, kindly come to regulation 12 onwards. Your lordships may kindly come to 12.
Yes.
Is it the liquidator shall make a public announcement in Form B, Schedule 2 within 5 days from his appointment. Then public announcement shall call all the stakeholders to submit their claims.
Yes.
Or update their claims submitted during the corporate insolvency resolution process as on the date the liquidation commencement date.
Yes.
So, Lord, there are similar provisions here. And Lord, your lordships will kindly also have a look at section 38. I think I have placed it. Where, Lord, it is an obligation on the liquidator to collect all claims. But under the Companies Act 1956, it was under, Lord, 2-3 sections combined together. Here, Lord, 38, consolidation of claims. The liquidator shall receive or collect the claims of creditors within a period of 30 days from the date of commencement of the liquidation proceedings. A financial creditor may submit a claim to the liquidator. Then an operational creditor may submit a claim to the liquidator. Then a creditor who is a party, who is party a financial creditor and party an operational creditor shall submit claims. A creditor may withdraw or vary his claim. Then verification of claims, admission, rejection of claim. Normal. great. No, no, আরেকটা section আছে. There is another regulation. যেখানে normal creditors can file. Just check it. But there is another regulation where these are not relatable to operational creditor and a creditor who is partly financial creditor and partly operational creditor. And there is also not the provision for other creditors. I'll come back to this, Lord. There is another provision. I'll just come back to it. In the meantime, Lord, may I just finish on this judgment? Lord, after 26, if your lordships, Lord, what is that? Regulation 20. It's regulation 20. I missed. Regulation 20. The other stakeholders can file, Lord.
Claims for other states.
20. Regulation 20. Now, Lord, if I may just come back to the paragraph, Lord, I was placing 26. Please come to 27. Once the property is sold, the assets of the company are required to be distributed to the creditors in order of preference. As the respondent municipality was not a secured creditor, the impugned judgment cannot be sustained. Almost a similar question in regard to the dues of electrical charges. This is not relevant. Please come to paragraph 29. Dues of the municipality would also not even otherwise come within the purview of the crown debt. Even a crown debt could be discharged only after the secured creditor and stand discharged. Then Lord 31, if your lordships kindly, for the reasons aforesaid, the impugned judgment cannot be sustained. Lord, as I said, that within the scheme of liquidation, Lord, there is no question of survival of a claim after the liquidation process have gone through. The creditors are supposed to, Lord, file their claim with the liquidator, and Lord, liquidator is supposed to, Lord, distribute the sale proceeds in accordance with the preference as framed in the statute. And it has an overriding effect. So, Lord, municipality can't, Lord, come back and say that we have not filed our claim before the liquidator, but even then we are entitled to claim, Lord, the area, the taxes from the purchaser. Now, Lord, the other judgments are all
The
not
only thing
in
is
line.
that how will the municipality, and Supreme Court is quite clear, I know, but there's one of the provisions which is there where I have also delivered a judgment, Mr. Mukherjee, but that's different.
That is, I tell your lordship,
That's different.
That is a marked difference with
Marked
this,
difference, yes.
because of the fact there the property was not auction sold. The person, because first is
No,
I
but
have
then
to see
my
whether
question
the
was, Mr. Carr, that how will the corporation be made aware of that these proceedings are being continued before the tribunal, and these orders are being passed, and these auction purchase will take place? To become a claimant, you have to first be made aware of the fact that these proceedings are initiated. This is what is happening.
Lord, there is public notices, Lord,
That's
which
the
are
only
issued.
way, right?
And the other thing is, Lord, the corporation has to, Lord, be also alert, because when a person, Lord, defaults in payment of their taxes, the corporation has to also be alert. But question today is, Lord, when I buy the property, do I have a liability in a liquidation process under the IBC? Do I have a liability, Lord, to pay the area taxes? That's the short issue that we are posing.
Correct.
Because my contention is that I am liable to pay taxes from the date, Lord, I have taken possession. There is no difficulty.
No, your contention is right to that extent that yes, you are buying the property as is, where is, or whatsoever it is.
And this as is where is will apply to the immovable property. But Lord, the public duties or public taxes, unless there is a specific, Lord, advertised notice point given in the sale notice that I have to
Be
pay the
liable
public
to
taxes,
pay the-
etc. Those are kept outside the liquidation process. Because, Lord, when the assets are sold, whatever the claims are, that has to go before the liquidator, and, Lord, through the liquidator, the disbursement has to take place. I take it with a clean slate, and that is one of the judgments, Lord, I will show to your lordship, where Supreme Court has said that if you buy a property through IBC or even through resolution process, you take it with a clean slate.
That is the main reason.
That even I have delivered a judgment. That's
I'm.
Here, that was resolution plan. If that fails, then only the auction comes in. So at that stage, the property was kept in the hand of the person who was the owners. And thereafter, the payments were being sought to be made by the owner of the property. Here, what happens? The resolution plan failed. Thereafter, went into liquidation, and in that liquidation, they have purchased through e-auction.
But under the IBC, there are two modes of sale. One is through the resolution plan. If the resolution plan succeeds, it's a transfer through the resolution plan. If the resolution plan does not succeed, because then it is sell, because the concept is first you try to sell it as a going concern.
Right.
If it is by a resolution plan, then the assets are sold as a going concern.
Correct.
The employees, their employment is saved. Revival. And the creditors who are supplying materials during the process of liquidation, their claim is also saved. Not the plan stage, but post plan stage, to keep the company afloat. Any supplies that is taken by the resolution professional,
Right.
that is also saved. So the process is the same, whether it goes through the resolution plan or through liquidation. Liquidation is when can't be revived. It is sold as a dead concern.
Yes.
Therefore, the assets
Lock,
only
stock, barrel, it is.
Lock, stock, barrel, it is sold, and the assets value is realized. Well, if it is through the resolution plan, some additional liabilities are passed on to the resolution successful resolution applicant. Now, the next judgment is also on the same line. This is 2023 volume 8 SCC. This is ISCO. I think I had shown these judgments. I just want to highlight the paragraphs. I think your lordships have already been taken through. This is also 2023 volume 8 Supreme Court cases, page 138.
Para 56.
Yes, before that paragraph 36, and then paragraph 55 onwards, if your lordships takes 55 to 57, 68 and 69.
The para 36, it has also been submitted that in terms of section 520 of the Companies Act, the municipal taxes as sought to be claimed by respondent number 1 would be cost of winding up. And the appellant being in possession of the assets is obliged to pay the municipal taxes which ought to have been paid to protect and preserve the property. Then which para?
Paragraph 55 onwards, if your lordships kindly takes 55 to 57. 55. As noticed and extracted in the impugned judgment of the division bench of the High Court in United Bank, the sale notice inter alia carried a significant stipulation whereby the purchaser put to notice to satisfy himself in respect of as regards movable and immovable assets as to their title, encumbrance, area, boundary, description, etc. therein. It was also stated the purchaser shall not be entitled to claim any compensation, deduction in price, etc. subject to all encumbrances. Such stipulations left nothing to chance and nothing of any ambiguity, where the purchaser was required to satisfy himself not only about the physical attributes of the assets, but also about all encumbrances, liens, and claims. Unfortunately, the terms and conditions of the sale in the present case fell too short of such material stipulation. We have reproduced herein before the contents of the sale notice dated 9th May 2003 in the present case, and the relevant terms and conditions of the technical expression were used in the present case by the appellant OL in the terms and conditions of the sale, that the same would be on as is, where is, whatever there is. This is the same condition which was there. basis, and then further disclaimer was stated that the appellant OL was not provided any guarantee as to the quality, quantity or specification of the asset sold. Such stipulation and disclaimers were definitely putting the purchasers to notice to get themselves acquainted with what the property is, the nature and extent, where the property is, the location attributes, and whatever there is, quantity and condition of the property. The bidders, purchasers were further warned to satisfy themselves in regard to the aspects of nature, extent, location, quantity, and quality after physical inspection of the assets, and were also informed that they would be deemed to offer with full knowledge as to the defects, if any, in the description, quality, or quantity of the assets sold. All such stipulations were essentially pertaining to the physical properties attributes of the assets in question. But the significant omission in those terms and conditions had been to make it obligatory on the bidder purchaser to make himself aware about encumbrances, liens, and claims attached to the assets in question. The omission strikes at the very root of the case of the appellant. The division bench of the High Court has rightly said that if the intending purchaser was required to satisfy himself in all respects, including encumbrances, he might not be heard in any objection about want of knowledge of encumbrances. But if he was not so warned, such an obligation on him to make himself aware about the encumbrances cannot be foisted by any deeming fiction. And then Lord, paragraphs 68, 69, and 71.
Yes.
I think I placed these paragraphs, Lord, on the last occasion. In case it is already placed, then kindly see paragraph 68. It has rightly been argued on behalf of the contesting respondents with reference to section 100 of 1882 Act and the decision of this court in AI Chavdani that in the absence of any statutory provision, the auction purchaser without notice of any charge could not be made liable for the areas of tax in question during the post-liquidation period. The provisions of the MP Act 1956 were not creating any such encumbrance or charge on the property, which would attach the property for all times and under all circumstances, nor they could be said to continue any encumbrance which diminished the value of the property. In contrast, they would be qualified as express of preserving, realizing, and getting in the assets of the company, and thus shall have to be paid in priority and before any other payment in the course of distribution of the assets of the company or value thereof. There remains another significant factor in the present case, that the property in question was indisputably governed by section 185 of the MP Act of 1956, which clearly provides that all sums due from any person in respect of taxes on any land or building shall be of the first charge upon the said land or building upon any movable property found within or upon such land or building. The proviso thereto further makes it clear that no arrears of any such tax would be recoverable from any occupier who is not the owner, if such arrears were for a period during which the occupier was not in occupation. In the face of the undeniable operation of the said 185 of the Act over the property in question, we are clearly of the view that the bidder purchaser was entitled to proceed on the assumption that even if there were any arrears of such taxes under the MP Act, the same would not be recoverable from him. Though, as aforesaid, the cryptic terms and conditions of sale in the present case, wanting in material stipulation, never obliged a purchaser to carry out a search as regards encumbrances. But even if such a requirement is taken into consideration on general principle of caveat emptor, the other assumptions available with reference to the section 185 of the MP Act cannot be ignored. Then Lord, paragraph 71. This being position, in our view, the company court and then the division bench of the High Court have rightly underscored the faults on the part of the appellant OL and have rightly held that the liability on account of the property tax and water tax claimed by the respondent number 1 to the extent rejected by the appellant OL has been a post-liquidation liability which the OL was to oblige to discharge in view of the omission of the sale notice and then in view of the operation of Rule 338 of 1959 rules. But Lord, one thing I must point out that this was none of these cases were Lord, cases of sale under IBC, which has a complete overriding effect. Here also, Lord, the municipality's stand is that there is, Lord, it is a charge on the property because of a section of the Kolkata Municipal Corporation Act. I'll place that. Now, Lord, just the other judgment, because Lord, there are number of judgments, Lord, where this view has been taken. In fact, there is a judgment of our High Court where also, Lord, in 2018 the same view has been followed. Graciam. But before that, Roman roadways, it is ordered. But I'll just not indicate the paragraph not because this is also to the same effect. So I wouldn't not take my lord's time. No, Ghansham Misra. Next. Lord, if your lordship's Lord in Raman roadways, this is Lord 2021 SCC Online Bombay 534. Lord, please come to paragraph 12 to 16 first.
That's point number 3.
This was Lord a notice demand issued under the Motor Vehicles Act. Paragraph 12, your lordships will find that. There was a non-user blood point that was taken in paragraph 13. Please come to paragraph 16. Lord, this transfer of vehicle, there was this charge was not levied.
Yes.
Paragraph 16, your lordships will find.
Yes.
Then, Lord, paragraph 46 to 48, if your lordships, Lord, kindly goes to. Thus, a claim made against a company in liquidation and for whom a resolution professional is appointed in CIRP must be submitted to and decided by the resolution professional so that the prospective resolution applicant knows exactly what has to be paid in order that it may then take over and run the business of the corporate debtor. This the successful resolution applicant does on a fresh slate. The decision of the NCLT in the case of so and so follows the decision of the Supreme Court in SR Steel Committee of Creditors and holds that the claims which have not been submitted or accepted or dealt with by the resolution professional and in the resolution plan submitted by the resolution professional would stand extinguished. The claim raised in the impugned demand notices would necessarily have to be lodged before the respondent number 4 as liquidator and can only be then decided by the liquidator, and where claims are not lodged, they appear to stand extinguished. Considering that in the present case, the CIRP proceedings in liquidation have not been completed, it would be open for the respondent number 2 and 3 at this stage to lodge their claim. In this case, Lord, the liquidation proceedings was not complete. So, and Lord, lastly, Lord, there is a judgment reported in 2021, volume 9, SCC 657. That's Lord Ghansham Misra, where this same principle has been pronounced. Lord, this is actually Lord following. Lord, if your lordships kindly take paragraph 65 to 71. Hmm. 65 to 71. This was, of course, Lord, a resolution plan.
Yes. Yes. Which para?
Lord, paragraph 65 to 71. Your lordships will find that there is a discussion. This is, of course, Lord, in the context of a resolution plan.
Right.
And your lordships can come to the conclusion. I think the conclusion summarizes Lord all the points. 102. instead of troubling your lordship through the paragraph. Page 60. 102. In the result, we answer the questions framed by us as under. That once a resolution plan is duly approved by the adjudicating authority under subsection 1 and 31, the claims as provided in the resolution plan shall stand frozen and will be binding on the corporate debtor and its employee members, creditors, including central government, any state government or local authority, guarantor and stakeholders on the date of approval of the resolution plan by the adjudicating authority. All such claims which are not a part of the resolution plan shall stand extinguished. The 2019 Amendment Act is clarificatory and declaratory. Consequently, all the dues, including the statutory dues owed to the central government, any state government, or local authority, if not part of the resolution plan, shall stand extinguished. In the light of the above, we now proceed to etc. So, Lord, what is happening is that insofar as resolution plan is concerned, unless these are part of the resolution plan, that gets extinguished. Insofar as the liquidation proceedings is concerned, that similar provision is that you have to lodge your claim with the liquidator. Unless, Lord, the claim is kept outside the scope of purview of the liquidation.
Yes.
And Lord, there is one judgment of our High Court that I just place it on record. This is 2018 SEC Online Cal 9630. Ache to? Grasim. Grasim bole? 9630. I'll hand up this. Ache? Ha. Ache. Total. Grasim dash. Grasim में है. Blood, please take judgment. Please take Lord paragraph 2 first. The learned advocate for the petitioner submits that a company went into liquidation by an order dated such and such passed by the High Court at Madhya Pradesh. The official liquidator attached to such High Court was advised the sale of an immovable property. The proprietor, the petitioner has participated in such sale. The petitioner was declared as the highest bidder in respect of the immovable property concerned by an order dated such and such. Petitioner was put in possession of the immovable property concerned subsequent thereto in view of the ratio laid down by such and such. E.I. Chabdani, learned advocate for the petitioner, submits that the charge, if any, for areas of municipal tax up to the date of the sale on the property concerned stand shifted to the sale proceeds subsequent to the date of sale of the petitioner is liable. The petitioner is paying the same, therefore the petitioner is entitled to the declaration as sought for and the mutation in respect of the property concerned. Learned advocate appearing for the corporation submits that A.I. Chabdani Industries in respect of an immovable property situated in municipality governed by the West Bengal Municipal Act. The provisions of 232 of the Kolkata Municipal Corporation Act are not available in the Act of 1999. Under section 232, corporation has the first charge on the immovable property concern. Consequently, the petitioner is liable to pay the areas. Also, otherwise, the corporation is entitled to proceed to recover the areas. Then in Chabdani, the purchaser of immovable property, sale conducted by a company, approached the High Court for a declaration that it was not liable to pay areas of property taxes prior to the date of confirmation of sale. It was held by the municipality is to look at the sale proceeds for the purpose of realization area claims. The purchaser immovable property is not liable to pay the areas of the property tax. Then, Lord, please come to paragraph 5. In view of the ratio laid down in Chabdani, the petitioner is liable to pay the property tax on and from the date of sale, being May 12, 2015. Corporation authorities are entitled to realize its claim on account of property tax prior to May 12, 2015 from the sale proceeds available with regard thereto lying with the official liquidator attached to the High Court at Madhya Pradesh. The petitioner applied for mutation. Corporation authorities will consider such application for mutation in accordance with law. In the event the corporation finds that the property tax payable by the period subsequent to May 12, 2015 are in arrears, it may raise such demands upon the petition. So, Lord, this is exactly on same line. Now, Lord, kindly, Lord, take the report that the municipality had filed. Yes,
the form of
initially, and then the affidavit. I'll just place that. Lord, has your Lordship got that? Kindly see the first page. The Lordships will find that they are raising claim from first quarter 2017-18. That is, Lord, first, second, third, fourth column. Last annual valuation with effect from, has your lordship?
Yes. First
This-
quarter 2017.
First model, then second one, and third and fourth. Then, Lord, next page, bottom of the paragraph, they have given the details of the outstanding as on 18th November 2024. Lord, unpaid tax, so far as second quarter 2022 is concerned, Lord, this is, Lord, during our tenure, because, Lord, 19 January 2022, we got the possession. This is, Lord, second quarter 22 to fourth quarter 24. Has your lordship found that? On the third page.
Yes.
This is, Lord, the period that we were in possession. This is second quarter 2022 to fourth quarter 2024. Now it will be increased. Then, Lord, kindly see the last line in this page. There is no document available with this department to indicate that claim was lodged by KMC for the outstanding property tax before the liquidator during the liquidation process. Period. However, section 232 of the KMC Act states that the property tax on land and building is to be the first charge on the premises. To quote, the property tax on land and buildings due from any person shall subject to the prior payment of land revenue, if any, due to the government thereupon be a first charge, etc. within the so and so. Therefore, the outstanding property tax, which is public money, cannot be quashed. Lord, the answer is just twofold. Section 238 of the IBC, which overrides, Lord, the provisions of the Kolkata Municipal Corporation Act, and, Lord, the property which is transferred by the liquidator, Lord, that is in the process of liquidation sale, which can't be touched, Lord, for the arrears. For the current, yes, it can be touched. So 232 has is overridden by the section 238 of the IBC. Then, Lord, kindly, Lord, take the affidavit which they have filed subsequently. Just take 2 minutes on this. Oh. Please come to paragraph 5.
Yes.
I'm not troubling your lordship with the exception to the report that we have filed. There, Lord, we have taken this point that 232 does not apply. Please come to paragraph 5. Kindly take the second sentence. It says, I submit that. Has your lordship got that?
Yes.
Writ petitioners are the auction purchaser of 4 units and 19 Canal South Road. It is admitted that they, being interested in the property in question, put up for auction, obtained expression of interest, and the terms and condition is annexed at page 39 of the writ petition, wherefrom it would crystal clear that the auction was as is where is whatever there is without precause basis. Moreover, the terms and conditions also made it clear that the intending bidders should satisfy themselves in all respect. It was clearly stated that the reserve price does not include taxes, levies, duties, or any registration fees or any other fees charged. The liquidator also clearly stipulated the purchaser shall bear and pay all taxes. It can be stated without any contradiction that the expression of interest, it would be abundantly clear that the petitioners have had direct and or constructive notice to the factum of arrear of property tax. Constructive notice. I crave leave to refer to UI at the time of hearing. Further, it is fallacious for the petitioners to urge before the Honorable Court, the corporation being an unsecured debtor, it should be creditor, can put up a claim of arrear property tax before the liquidator. So, Lord, 2 things. First, they say that expression of interest keeps their charges outside the purview of liquidation. This is, of course, my learned friend will have to establish. And secondly, they say that as unsecured creditor, they have no recourse before the liquidator. These are the 2 points. And then Lord, paragraph 6, it says with reference to the allegations so and so, and then it says it is submitted that in view of the law already laid down by this honorable court, it is an imperative obligation of the petitioners to make payment of the area property tax dues of mutation for mutation of their name in the purchased property in the municipal records of the corporation. Further, it has been laid down that as is various basis, there is so and so is noticed to every intending bidder that shelter does not undertake. Now, Lord, the twofold answer to this, that Lord, the judgment that my learned friend is relying upon, Lord, once he places the judgment, I'll deal with it. I'm not troubling your lordship with the judgment now. This is an old Calcutta High Court judgment, Roshomoy Das. Let him place the judgment, Lord. I'll deal with it.
Yes.
And secondly, Lord, as I said, as is where is basis has now been explained by the Honorable Supreme Court. Says that specifically if the notice contains that public taxes, public dues will have to be paid, that would be separate. But otherwise, a reading between the lines will not do. There has to be a complete notification that public dues stands outside the purview of the sale proceeds. That is not the case here. As is where is basis does not help my learned friend. So, Lord, these are my submissions. I say, Lord, the area property tax. Area property tax is not, Lord, my liability. It has to be, Lord, he has to collect it from the liquidator, or Lord, they have really missed the bus. Here, Lord, the liquidation proceedings is concluded. These are my submissions.
Choose, my lord. First is mutation, whether I am supposed to grant mutation in spite of the fact that the area property tax is there. That's one issue. Now, that area property tax, whether he is liable to pay or not, since he is an auction purchaser,
Yes.
is a corollary to the first issue, but your lordship has to consider that corollary first, then come to the main question of mutation. Now, so far as the mutation is concerned,
See, if I hold that he's not entitled, then the mutation will automatically take place.
Of course, yes. If your lordship holds that in the factual
The first thing
matrix,
which
I cannot claim.
Yes.
Then, my lord,
that is the most important
yes,
thing which has.
I will go to that. In the factual matrix, if I cannot claim, naturally, my lord, the mutation follows as he has claimed. Now, this is an auction purchase. He is an auction purchase.
Yes.
No dispute about it. Now, if your lordship kindly takes up the e-auction notice. My lord, I'd be troubling a bit.
No, please.
Because my learned senior friend, what he has placed, some of the paragraphs I would be placing again in my own way.
Yes, yes.
My lord, it starts at page 39 and 41.
Yes.
41 is the, your lordship takes, my learned friend has placed it, but still I am placing it.
Yes.
An expression, my lord, that fourth paragraph, an expression of interest is invited from investors, consortium of investors, herein referred to as the applicants, meeting the eligibility criteria to acquire the assets of the company through e-auction and as per details mentioned herein. The assets of the corporate debtor are being sold as is, where is, whatever there is, and without recourse basis. There is no dispute about it. And such sale, said disposition
is without any kind of warranties and indemnities. So about this, there cannot be any dispute. Now, my lord, would kindly turn to page 45. What he has purchased in e-auction, though it is said to be module, but they are landed property. Now, my lord, would kindly come to page 45. 623.
Yes.
Prior to that, the description of the landed property is given at page 42. Then your lordship would kindly come to page 45. 623.
Yes.
The shortlisted applicants may note that the information memorandum is not all inclusive. Single window source of information relating to the sale asset and is provided solely for the guidance of the applicants. Information memorandum is a compiled document and may contain such information which may or may not have been independently verified by the liquidator. Hence, applicants are advised to satisfy themselves in all respect independently before submitting their bid in e-auction. My lord, this is a caveat in my respectful submission. This is a caveat inbuilt by the liquidator at the very outset, saying that whatever I have said might not contain all such information, but it is the duty of the applicant or advised to satisfy themselves in all respect independently before submitting their bids in the e-auction. My lord, when I buy a property in e-auction, my lord, the property tax is associated with the property. Is there any document that my learned friend's client went to the corporation and inquired that kindly show me whether there is any due or not in respect of the property tax of this property? And I'm going to purchase it in e-auction. If he shows I am out of the court, then my lord would kindly come to page 45. Oh, sorry, 45 I have placed. Now, my lord would kindly come to page 48. Again, it starts with, my lord, the terms and condition of the proposed sale. It is again starts with the as is where is basis and without recourse basis. Now 2.1.3, the applicant should thoroughly, again, my lord, sees the caveat. The applicant should thoroughly satisfy itself about the nature, condition and quality of the sale assets, that is whatever is there, and the liquidator gives no guarantee, warranty to the title of the sale assets or the condition of the assets, materials or its quality for any specific purpose or use. It should be clearly understood that no complaint about the title, quality, condition, fitness for use will be entertained by the liquidator. Then, my lord, 7.1.4. It shall be presumed that all the facts were taken into account by the applicant while submitting the bid. Even if the applicant chooses not to inspect or conduct due diligence of the sale assets, it shall be presumed that the applicant has made himself aware of the physical condition, market value, etc. My lord, pausing here. I am buying a property, and if there is a property tax in this way, my lord, I am buying a property of 1 crore, and if there is an property tax of 20 lakhs, that diminishes the value of 1 crore. I am putting a bid of 1 crore in respect of a property, and there is 20 lakhs tax to be paid. So that 1 crore is actually 1 crore 1.20, or rather that 20 lakhs diminishes the value. Now, my lord would kindly read now this 7.1.4. It shall be presumed that all the facts were taken into account by the applicant while submitting its bid, even if the applicant chooses not to inspect or conduct diligence of the sale assets, it shall be presumed the applicant has made himself aware of the physical condition, market value, etc. Sorry, of the etc. sale assets, and therefore no claim against the same shall be entertained in this regard by the liquidator after submission of the bid form. Then, my lord, my learned friend has placed 7.1.10. That I think is most important in this, how your lordship interprets it. The reserve price fixed by the liquidator for the sale of assets of the company is exclusive of all taxes, my lord, levies, duties, or any registration fee or any other fees or charges. My lord, normally a situation what my learned friend is arguing, the reserve price is say 20 crores. He is asked to put up a bid. Now a claim before the liquidator will only arise if he has taken into consideration the taxes associated with the property. But what he says over here, he says very clearly, the reserve price for the sale of the assets of the company is exclusive of all taxes. Again, it is a caveat that the reserve price, what I have mentioned, is exclusive of the taxes. It's a caveat. Kindly go and inquire what are the taxes due in respect of this property. It's already said that the person who is bidding has to apply, he has to be diligent, due diligence. Due diligence has been asked for at every stage by the liquidator. Every point, my lord, is a caveat upon the person who is putting up his bid. And it says very clearly, exclusive of taxes, levies, duties, or any registration fee, or any other fee, charges. My learned friend is saying that I admit I am an unsecured creditor. I go and put up a claim only to be sued out by the liquidator. He will say that the reserve price, what the auction purchaser has paid, is exclusive of taxes. Who are you to claim the taxes? I have made it very clear. My lord, in Hindi they say na ghar ka na ghat ka. So I become that. I cannot place my claim before the liquidator. Then my lord would kindly take page 48 I have placed, page 49. 49. The purchaser shall bear and pay the applicable stamp duty, that is their registration fee, all fees, expenses payable for registration of the documents, taxes, GST, and all other duties payable in connection with the purchase of the sale assets. Malad, it doesn't say by any means that from the date of registration of the convents. Is very clear, open, that all payable, Malad marks this word, all payable. Payable means associated with the property, whether it is past or present. Bol. Expecting that the reduction then my lord would kindly come page 50. My learned friend has placed this, but again, my lord, I am placing that 9.4. The information contained in the invitation is substantially based on estimated information, options, opinions, and information sourced from the stakeholders, public domain, and independent third parties. the invitation does not amount to any recommendation either expressly or by implication, which with respect to the company or other entitles mentioned in the invitation, except where the specifically mentioned otherwise, the liquidator has not independently verified such information, and the same is being provided to the liquidator for information purpose only. The liquidator does not make any representation or warranty of as to the accuracy, reliability, or completeness of such information, and does not assume any undertaking to supplement such information as further information becomes available or in light of the changing circumstances. The liquidator shall not have any liability under any law, statute, rule, or regulation for any representation or warranties, except or implied, contained in, or any omission from the invitation or any other written or oral communication transmitted to the recipient in the course of evaluation of the proposed financing or otherwise. My lord, evaluation of proposed financing or otherwise will also, while doing that, it is to be presumed, my lord, he has taken into consideration clause 7.1.10, which very clearly said that the reserve price excludes all taxes. Now, my lord, again at page 51, your lordship would take 9.9. The terms of the invitation are to be read subject to the disclaimer. The provisions of this disclaimer take precedence over any other provision of invitation which is inconsistent with or otherwise conflicts with the provision of disclaimer. So, these are the conditions based on which he purchased. Now, my lord, the very clear thing is, as is, where is basis, and no records basis. That is clear. My learned friend has shown so many judgments saying that what is the implication. Now, my lord, would kindly, my lord, sorry, I'm troubling your lordship.
No.
Your lordship kindly gives me that K.C. Ninan. I'll give a fresh copy.
Yes.
My lord, I'd be placing 2023 14 SCC 431. ওই দুটোই আমাকে দিয়ে দিন, আমি সাহেবকে ফ্রেশ কপি দিচ্ছি। 2023
So this way will,
SCC page 431.
Mr. Mukherjee will have this after lunch. The judgments after lunch.
After lunch. Very good.
We won't be able to finish it.
I will, my lord, take the rest of the day.
That's okay. We have one matter at 2.
Yes.
Then thereafter.
We'll see that.
That is also for hearing.
That is also.
You can keep it after the vacation if you
We'll
want.
finish it at least one matter.
Very well.
Yes.
Your lordship finishes.
Otherwise, I'll also. The rest of the matters are released for the day. These 2 matters will take.
After the lunch.
I've handed up 2023-14 SCC page 431. That is the judgment in the matter of AC Ninan versus Kerala State Electricity Board and others.
For that 2 o'clock matter, let
My
me
lord,
just. So I
My
want,
lord, I was told that perhaps,
this will go on,
my lord. My lord, then keeps it after vacation.
then I'll keep it after vacation. एक मिनट दिखाना file. Then. The 2 o'clock matters.
Pastry or meat. Yeah, pastry or pastry. Sugar cream pastry. Black forest cake. The birds. 0 calorie.
No lactose, cream lactose free.
Mr. Carr is also, probably he was here, so he's aware.
Mr. Kaur was there.
Yes. Yes, he's appearing for Mr. Carr.
Mr. Mojumdar probably is appearing for the.
In the other matter, yes.
In the other matter, he also came. I told him that this is the.
Okay,
I told him.
you don't. So we'll keep it after vacation. Or you want to try your luck next week?
My lord, even that can be done.
Or try your luck next week?
Thursday.
Take down. At the request of the parties, let this matter be listed. This would be next Thursday would be what? 25th. It would be next Thursday. Achha. All right, so we'll try on 18th.
My lord,
18th?
18th. 2 p.m. My
2
lord.
p.m. 18th. We'll see if we can. Both the matters. 17. What is 17? There's another matter which is kept at 2 p.m. Which one is this?
10 and 11. Your lordship, 10 and 11.
10 and 11 is done. 17 also, I'm told.
My lord, because those are both challenging the same amendment act, my lord. So my lord was keeping them together. The
All
same
right.
amendment act.
So
is
they're all connected to each other.
not connected, but my lord, they can be kept one after the other, my lord.
17 is 7. Who's in 17? Item 17? In 17. Is there any similarity? No similarity between these matters, right? You're appearing in 17?
My lord, I am appearing in item number 17. I'm being led by Mr. Arindam Banerjee.
Yes.
He's on his legs, my lord. I'm just taking a
Lord, an interim order is expiring.
interim order was there which is expiring today, my lord. It's the last day of the interim order. It was 6 weeks, which was granted on 31st of July 2025.
Mr. Ghosh is there in this matter. You're
Mr. Alok Kumar Ghosh is on the other side, my lord.
She has made some submission.
so we'll when is the interim order expiring?
My lord, today.
Today.
My lord, it was the 31st July 2025 order, and your lordship was pleased to grant an extension of 6 weeks. Lord, the 6 weeks is expiring today, that is 11 September.
Next Thursday. Let it be next Thursday.
My lord, interim order may be extended till then.
Interim order granted earlier is extended. At the request of the parties, let this matter be listed on 18th. Interim order granted earlier extended further for a period of 2 weeks or until further orders, whichever is earlier. We'll see next week.
Grateful, my lord.
Mr. Mukherjee, Mr. Banerjee, this item 17, what is this regarding? This is
Item number 17. That is the Nico House demolition case, my lord, where without giving us any notice in respect of a proceeding which is continuing, suddenly our 7th floor office is sought to be demolished when the rest of the proceeding is continuing qua the others. So we had taken up the point that we could not have been dissimilarly dealt with when the fact finding is still on.
But you were a tenant or something?
No, I'm an owner. I'm an owner. by a registered conveyance taken from the liquidator.
Okay.
Therefore, it's not that I'm a fly-by-night operator or a tenant planted to protect an unauthorized construction. Now, entire matter is at large before the special officer because the plans of the premises are being hunted out and being placed before him. Special officer has given procedural directions for a number of things to be given. Suddenly, in the teeth of all this, an interim order of demolition is passed against my 7th floor building when the other proceeding is still at large. So that's what my lords have protected. The other side has come up.
All right, so that interim order for a period of 8 weeks kar dena usko. We'll see next week. We are giving a date.
Yes.
By interim order for 8 weeks, and we are keeping it next week. We'll see if we can do
The
something.
widest matter, Lord, kindly, if your lordship takes up before the vacation just once, next week.
Yes, we
next week.
have. We'll try to. Let's see.
Yes.
Yes.
My lord, I have placed that. Now,
Yes.
my lord, your lordship would get the idea what this case deals with. Your lordship would kindly come to paragraph 1. Thereafter, I'll take up the issues
Yes.
and the decision. The 19 cases in this batch of appeals, para 1, follow a similar pattern of facts. The supply of electricity was discontinued due to the failure of the previous owner to pay the dues for consumption of electricity on the premises. The previous owners had borrowed money or raised loans on the security of the premises. In some cases, the erstwhile owner went into liquidation. Malad would mark this. The premises were sold in auction sales, generally on an as is where is basis. Malad would mark these 2 sentences. The new owners who purchased the properties in auction applied for new electricity connection for the premises to which electricity has been disconnected for failure to pay dues. The electric authorities refused to provide an electricity connection unless auction purchaser paid the dues of the previous owner. Malad, instead of electric connection, your lordship would read the corporation refused to grant mutation unless the dues of the previous owner has been paid. This is the only dissimilarity with the.
No, we don't know what is there at the time of auction purchase. What are the terms and conditions which have been put in the notice?
It is there. I'll show it. This refusal was derived from the powers conferred by the subordinate legislation, notification, electricity supply code, or state regulation. The denial of electricity supply resulted in the institution of the petitions under 226 before the court, leading to the judgment which are in appeal. Now, my lord, I do not want to waste your lordship's time. Kindly come to subparagraph G under paragraph 24, which your lordship would get. Subparagraph G under paragraph 24. Did my lord get 24?
Issues.
Yes, issues. What is the implication of an auction sale of the premises on as is, where is basis, with or without reference to the electricity areas of the premises? So what they are emphasizing upon in my humble reading, as is, where is basis, if the auction sale takes place, which is the case over here. Then my lord would kindly take up paragraph 28 onwards, which is the universal service obligation is not absolute. Now, my lord, I would be placing paragraph 35. Paragraph 35.
Yes.
Here their lordship was considering to Electricity Act of 2003. Section 47 indicates that a distribution license can refuse to supply electricity under Section 43 if the applicant fails to furnish requisite security. Under Section 48, a distribution licensee may require the applicant who requires a supply of electricity in pursuance of Section 43 to accept one, any restriction which may be imposed for the purpose of enabling the distribution licensee to comply with the regulation made under Section 53, and 2, any terms restricting any liability of the distribution licensee for economic loss resulting from the negligence of a person to whom electricity is supplied. Thus, it is implicit that the distribution licensee may refuse electricity supply to the applicant until they accept such terms and restrictions reasonably imposed by the distribution licensee incidental to the statute. Here I will be placing, my lord, Section 183(5), and also I will be placing, my lord, Section 232 of the Kolkata Municipal Corporation Act. Then your lordship takes 36. Further, Section 50 empowers the State Commission to specify an electricity supply code providing for recovery of electricity charges. Among other things, the electric utilities have urged that the duty to supply electricity is subject to the electricity supply code specified under Section 50, as mentioned in the preceding paragraphs. An applicant is required to submit a completed application along with the document showing payment of necessary charges and other compliances. The electricity supply code can stipulate such other compliances that an applicant has to observe for getting the supply of electricity under Section 43. Therefore, reading Section 43 along with Section 45, 46, 47, 48 and 50, it becomes evident that the right of an applicant to seek supply of electricity under Section 43 is not absolute. The right is subject to the payment of charges, security deposit, as well as the terms and restrictions imposed by the distribution licensee. Now, my lord, if your lordship sees Section 153 or 183 for once, 183 for the Kolkata Municipal Corporation Act. As I have submitted, my lord, subject to correction, instead of electricity charges, your lordship
183.
183. First, your lordship sees 183.
Notice of transfer.
Yes, this is relating to mutation. Now, my lord, would kindly come to 5. The municipal commissioner shall, on receipt of a notice of transfer or devolution of title under this section, record such transfer or devolution in a book and also in the municipal assessment book, subject to the payment of arrears of taxes and dues to the corporation on account of transfer of the predecessor in interest of the applicant and the processing fee. So the predecessor in interest, whatever the dues have been left, has to be paid while he makes an application for transfer, and it has to be paid. And now, my lord, notwithstanding anything contained in subsection 6, sorry, that's register. No, subject to refuse. My lord, 5, then there is a clause which says that the mutation can be refused. Notwithstanding anything contained in this act, municipal commissioner on his own.
Provided that nothing,
Subsection 8.
subsection provided that nothing in the
Provide.
subsection shall derogate from the
Yes.
power of the corporation to review.
So first is the person who is purchasing 183(5) imposes that liability, and 8 gives me power proviso to refuse mutation. Now, my lord, this electricity charge has to be just changed in this judgment, subject to what falls from your lordship, with the property tax. Now, my lord, the next paragraph.
Subsection 5 is proviso.
Huh.
Proviso to subsection.
Now, my lord, the next paragraph is, now, my lord, straightway come to pay paragraph 93. देखो.
Yes.
Could I indicate, my lord, what are the paragraphs I would be relying so that your lordship can note? 93, 94, 95. Apart from the one I have already placed, 100, 107, 116, 117, then 137, 38, 143, 145, 147, and 148. These are the paragraphs I will be placing before your lordship. কোন গুলো বলো?
Rest paragraph.
93, 94, 95. তারপরে 100, 107, 116, 117. তারপরে হচ্ছে 137, 38, 143, 145, 147, and 148. ঠিক আছে? Electricity, my lord, 90, I'm at 93. Electricity constitutes a public good. The court's interpretation of law must foster this position. In Hyderabad Vanaspati Supra, this court was adjudicating upon the validity of clause 39 of the conditions of supply, which defined various malpractices and provided for inquiries by the designated officials. This court observed that it was the statutory duty of the board to supply, transit, and distribute electricity throughout the state in most efficient and economic manner. It was observed that terms and conditions such as clause 39 were necessary to prevent unauthorized use, pilferage, malpractices by the consumers. Such terms were necessary to recoup the loss suffered by pilferage and to stop continuation of similar malpractices. Now, I'm not pausing here. What the corporation does with the property tax, well, Lord, what we provide, first your lordship has to consider what we provide. There might be some shortcoming in the service what the corporation is providing, but your lordship would consider that we provide the entire water to the entire city, potable water to the entire city. We provide city lights on the streets. We maintain the streets. We maintain the sewage. We clear the garbage. Now, Mala, to defray all
To
these.
allow unauthorized constructions.
my lips get stitched. Now, Mala, these are the some of the human service what I may submit. We provide. Then during this COVID, we provided free of cost vaccination. Well, it has been ultimately given by Kolkata Municipal Corporation from the health centers. Now,
if we do our duties, Mr. Mukherjee, this will be the most ideal state to live in.
Yes.
Or for that matter, any corporation. I'm not talking about
now
Kolkata.
This money, what is received by these taxes goes to defray these expenses. There's an expense, overhead expense. So that goes. Now,
Not
Of
only
course,
that,
we
you,
have to
you
provide.
pay your employees, you pay all those taxes which you collect from municipal taxes, property taxes, goods taxes, all these taxes, octroi taxes. I'm sure octroi also you must be collecting.
road taxes,
Road-
corporation পায় না।
Road tax, octroi, that doesn't come to corporation proper.
Doesn't
Matlab,
come?
we get those
License-
advertisement,
Advertisement,
then building sanction,
building sanction.
then property tax, then licenses for these shops and markets. We get all these things. Amusement tax, all these we get. Number 94. Apart from protecting a public good, such conditions also have a reasonable nexus with the objects of 2003 Act, such as a robust development of electricity industry, protecting the interest of the consumers as well as the financial interest of the distribution licensees. The need to protect the financial interest of distribution licensees has been explicitly recognized in Section 61 of 2003 Act, which empowers appropriate commission to specify the terms and conditions for determination of tariff in accordance with the commercial principle. The relevant part of 61 reads as follows. My lord, I am not troubling with the 61. Then, my lord, 95. The condition of supply and electricity code, which require payment of electricity dues of a previous owner as a condition for the grant of an electricity connection, have a clear nexus to the scheme of the parent legislation and the objectives sought to be achieved. It is just and reasonable for the distribution licensee to specify condition of the supply requiring the subsequent owner or occupier of the premises to pay the areas of electricity due of the previous owner or the occupier as a precondition for the grant of electricity connection to protect their commercial interests as well as the welfare of the consumers of electricity. That was the reason why I placed 193, 5 and 8. Now, my lord, would see section 232. 232. Allah has got 232. The property tax on land and building to be the first charge on the premises. Malad, just note that it is the first charge on the premises. The property tax on land and building due from any person shall, subject to the prior payment of the land revenue, if any, due to the government thereupon, be a first charge on the land and building belonging to such person and upon the movable property, if any, found within or upon such land or building. So property tax is first charge on the land, and even it encompasses the movable property found in that land, because we come up with those challenges to the distress.
Yes.
When we go and put up a padlock for realization of the dues, that power emanates from 232. So it becomes a first charge, and if your lordship, now 95 I have placed, I can hedge that my power to grant mutation can be hedged with the condition that unless you pay, I will not grant you mutation. Proviso to section 183(5). Then my lord would take 100. Rather 99 also, my lord. Your lordship would kindly. An encumbrance means a burden or charge upon the property, or a claim or lien upon an estate, or on the land, encumbrance must be a charge on the property which must run with the property. 232 is very clear. In terms of the first paragraph of section 100, when an immovable property of any party is pledged as a security for the payment of money to another, and the transaction
তুমি 5 এর প্রোভাইসো বলছো, 5 এর তো কোনো প্রোভাইসো নেই।
এই প্রভিয়ার প্রভাইসটাকে দেখি
নিউ বেয়ারেজ ইজ
183.
183,
but in my book there is no 5 proviso.
That's the fault in the book,
is there,
not in the act.
And though in recent days, anyways, যা আছে বইয়ে আমি সেটাই বলছি। সে ভুল হয়েছে কিনা বেটা তুমি
Your
বলতে
book
পারবে।
has that. 183, kindly come to 183.
183 subclause 8 proviso.
Plus,
5 there.
plus 5.
The 182A.
183 subsection 5 provides.
হ্যাঁ, subsection 5 ই দেখলাম।
আচ্ছা,
No?
এটা 182 পড়ছে
না রে বাবা, হ্যাঁ, 182
শুরু হচ্ছে
চল। 5
This is
provided nothing in this section shall derogate from the power of the corporation to refuse mutation. Pages?
it is inserted later.
on account of area.
Well, I was placing 99. Better well place 99.
An encumbrance means a burden or charge upon the property or a claim or lien upon an estate on the land. Encumbrance must be a charge on the property which must run with the property. 232 of my act is very clear. It creates a statutory charge on the property, so far as the property tax is concerned. In terms of the first paragraph of section 100, when an immovable property of one party is pledged as security for the payment of money to another, and the transaction does not constitute a mortgage, the latter would acquire a charge over the property. All provisions that apply to a simple mortgage are applicable to a charge. A charge is neither a sale nor a mortgage because it creates no interest in or over the immovable property, but it is only a security for the payment of money. In other words, a charge only results in creation of a right of payment out of the property towards the satisfaction of the debt or obligation in question. Then 100. Yes, my lord, 100. The second paragraph of 100, section 100 provides an exception to the general proposition that a charge runs with the land and can be enforced even if the property has passed into the hands of the third party. It provides that a charge cannot be enforced against a property in the hand of the transferee without notice. The words save as otherwise expressly provided by any law for the time being in force indicate that a charge can be enforced against a transferee without notice when the express provision of the law exists. In my case, express provision of the law exists. Hence, a charge cannot be enforced against a transferee if they have no notice of the same, unless the requirement of such notice has been dispensed with by the law. Then my lord would kindly come to 107. Solve holo. Then my lord comes to 107. Consequently, in general law, a transferee of the premises, jeta Dipankar relay koreche, premises cannot be made liable for outstanding dues of the previous owner, since the electricity area do not automatically become a charge over the premises. Such an action is permissible only where the statutory condition of the supply authorized the recovery of outstanding electricity dues from the subsequent purchaser claiming fresh connection of the electricity, or if, I put emphasis, or if there is an express provision of law providing for creation of a statutory charge upon the transferee. Now, my lord, this particular section has been relied upon in a subsequent Supreme Court judgment in I'll just, because this 107 has been relied upon 2023 10 SCC page 60. I'll provide my lord with a fresh copy. My lord would pardon me, I have marked it.
That's okay.
Page 40. Because this is only, this paragraph is only required in this judgment. Because the subsequent Supreme Court relies on 107 of Kesinina. So if a statute creates a charge and you have purchased the property under e-auction, you cannot take shelter of this IBC and all that. And also terms and condition and other provisions. Malad, now take 116. The provisions of statute and statutory condition of supply need to be examined to determine whether the condition of supply provide for creation of charge in terms of section 100 of the Transfer of Property Act. Once it is established that a statutory charge is created and required notice was given, the charge attaches to the property and the licensee is entitled to recover the unpaid electricity dues by proceeding against the premises. Consequent to the charge created, Article 62 of the Indian Limitation Act 63 would come into play. Article 62 of the Limitation Act relates to enforcing the payment of money procured by mortgage otherwise charged upon the immovable property. The electricity utilities would get a period of 12 years to recover the dues charged on the immovable property from the date when the money payable became due. Then my lord would consider 117. In the light of the above discussion, we are of the opinion that the electricity utilities can create a charge by framing subordinate legislation or statutory condition for supply enabling the recovery of the electricity areas from the subsequent transferring. Such a condition is rooted in the importance of protecting electricity, which is a public good. Public utilities invest huge amount of capital and infrastructure in providing electricity supply. The failure or inability to recover outstanding electricity dues of the premises would negatively impact the functioning of such public utilities and licenses. In the larger public interest, conditions are incorporated in the subordinate legislation. Here it is not subordinate legislation. Here is the legislation itself. Corporation Act itself. I have not framed any regulation or rule or notification, because the point would be taken that subordinate cannot override the main if it's not provided in the main. Then, my lord, would come to (136). Then I take to your lordship to 136. We therefore, my lord, in view of the discussion and the various judgments noted in this judgment itself, the court comes to this finding. We therefore reject the submission of the auction purchasers, my lord would mark, that the recovery of outstanding electricity areas by instituting the civil suit against the erstwhile consumer or from a subsequent transferee in exercise of the statutory power under the relevant conditions of supply is barred on the ground of limitation. So the court rejects limitation part in 136. so far as raised by the auction purchaser. Then, my lord, would kindly come to 138. Oh, sorry. 136, if your lordship turns over, that Roman 7, implication of sale of premises on as is where is basis, with or without reference to the electricity areas of the premises. My lord, this is one of the issue framed by the Honorable Supreme Court, as I have placed before your lordship. Now, how this issue is being answered? The electricity utilities have urged that the auction purchasers were put to notice of the requirement of the clearance of the dues to the public auction sales of the premises were held on as is where is basis. This would include a condition of acknowledging all liabilities in respect of the premises with or without specific reference to the payment of electricity dues. My lord, just marks it. In a sale arising out of a commercial transaction, the auction purchaser is required to undertake due diligence of outstanding dues which are premises specific. On the other hand, the auction purchaser submitted that a condition such as is where is a feature of physical property and does not extend to the claim, which are not charges or otherwise encumbrances running with the land, which is my learned senior friend's submission. The argument finds support in the decisions of Punjab Urban Planning Development Authority, Raghunath Gupta, Delhi Development Authority, Kenneth Builders, and the Developers Private Limited. Electricity dues cannot be ascertained merely by looking at the property. There was no obligation of the applicants to ascertain the electricity dues payable, more so in view of the judgment of Isha Marbles. Probably today my learned friend had not relied, but on the first day while he was arguing, my lord, he referred to Isha Marbles before your lordship. Now, my lord would kindly take 143. Thus, my lord has got 143.
Yes.
Thus, the implication of the expression as is where is, or as is what is basis, or as is where is whatever there is and without recourse basis, is not limited to the physical condition of the property, but extends to the condition of the title of the property and the extent and the state of whatever claims, rights and dues affect the property, unless stated otherwise in the contract. The implication of the expression is that every intending bidder is put on notice that the seller does not undertake any responsibility to procure permission in respect of the property offered for sale, or any liability for the payment of duties like water, service charges, electricity charges for power connection, and, my lord, taxes of the local authorities, amongst others. And I have shown, my lord, in my humble endeavor, showing the conditions and the EOI, that at the every stage, in every clause, the liquidator emphasized upon that kindly exercise your due diligence. I do not take any responsibility towards any liability so far as this property is concerned, particularly that clause, which is very important, which I placed, my lord would pardon me to place it once more at the cost of repetition, that the reserve price of the sale of the assets of the company is exclusive of taxes, levies, duties, or any registration fee or any other fees and charges. Now, while putting up his bid, He must have discounted all these things. Then thereafter he has put up his bid. And he has exercised his due diligence. He cannot now say that I have not exercised my due diligence. And if he has not also, the term says that it is to be implied that you have done so. And you have not done so, it is at your own peril. Yes. And that's what Supreme Court in this case in Inan explains and holds. Now, my lord would kindly come to paragraph 145. My lord, in 145, the court was considering the judgment in Srigdha beverages. Your lordship has seen 145?
Yes.
This court was considering an auction sale under securitization and reconstruction of financial asset and enforcement of Security Interest Act. The court analyzed the clause 24 and 26 of the auction notice, which stipulated as is where is sale with respect to all statutory dues, absolved the authorized officer of all liabilities for any charge, encumbrance and dues, including the electricity dues. It concluded that the auction purchaser was clearly put to notice, since there was a specific mention of the quantification of the dues of various accounts, including electricity dues, on the liability of the past owners to bear electricity dues. When the sale is on as is, where is, the existence of electricity dues is specifically mentioned, this court categorically held that the auction purchasers were bound to inspect the premises and provide for the dues in all respect, this court observed, where, as in the case of e-auction notice in question, the existence of electricity dues, now my lord, mark the words, whether quantified or not, has been specifically mentioned as a liability of the purchaser, and the sale is as is, where is, whatever there is, and without recourse basis. There can be no doubt the liability to pay electricity due exists on the respondent purchaser. So, this argument, with the deepest respect to my learned friend, senior friend, the argument what he had made in the morning, he cannot take shelter to these judgments. And particularly, my lord, your lordship has noticed he had placed AI Chavdani, and thereafter he had placed 3 judgments based on AI Chavdani.
Yes.
Now, my lord, in this judgment, that one I have provided, my lord, K.C. Nina, your lordship would kindly come to the list of judgments relied upon. My lord would pardon me, I have put a red mark on the AI Chavdani.
আমার কাছে ওই কপিটা নেই ওই কপিটা নেই
Mallar has got that glossary of the cases relied upon. I'll show it.
series of cases relied
Series.
After 3, 5, 3 page, 4
Your
pages
lordship
of the-
gives me also.
Acting document.
Accident.
পড়ে থাকে শেষে অবশ্যই
Amid their hearing, only one thing to point out, of which we may take the responsibility, that 183(5) proviso that has been shown, that we have also checked from Sharthok as well as from the Gazette publication, that portion has been deleted. That is deleted, my lord, from the Gazette publication. একটু দেখাবেন, একটু দেখাবেন একটু যত্ন করে এটা।
Even if it is deleted, does not.
Even if it is deleted, it cannot be strenuously relied upon.
I am not relying on
Oh,
that.
এত তত্ত্ব কথা বললেন তো, আচ্ছা। That is from the Gazette pub. এই ইন্টারনেট থেকে তো কারেন্টটাই বেরোবে।
All right, that has been deleted.
Yes, my lord. That has been clearly so.
Even there it is mentioned, the act which here also it's mentioned. I have noticed it, there also it is mentioned.
Yes, that's, we were amid the submission, my
You-
lord, sorry,
if you
but we
read
had to
the-
point it out. At that time, we didn't point out, but now, my lord.
Substituted, it read earlier as so and so. The earlier portion is reading.
That is the, yes, my lord.
Deleted. There, let us go by it is deleted. So first is, it is fastening a liability. He has to pay the dues of his areas, of his previous owners, and then, my lord, so far as 232 makes it very clear, creates a statutory charge on the property, and it is the liability of the subsequent purchaser. So when he purchases, he inherits the legacy of the earlier owner of the property. Now, my lord, I was placing 145. Then, my lord, 147. 147. In terms of the, my lord, 147, your lordship?
Yes.
No, 146 also your lordship takes notes of. To conclude, all prospective auction purchasers are put on notice of the liability to pay pending dues when an appropriate as is where is clause is incorporated in the auction sale agreement. It is for the intending auction purchaser to satisfy themselves in all respect about the circumstances such as title, encumbrances, and pending statutory dues in respect of the property they propose to purchase in a public auction sale. Auction purchasers have the opportunity to inspect the premises and ascertain the facilities available, including whether the electricity is supplied to the premises. Information about the disconnection of the power is easily discoverable with due diligence, where the liquidator says in all clauses, kindly exercise due diligence, which puts a prudent auction purchaser on reasonable inquiry about the reasons for the disconnection. When electricity supply to the premises has been disconnected, it would be impossible for the purchaser to assert that they were oblivious of the existence of outstanding electricity dues. My lord, I have shown the liquidator has said that the reserve price does not include X, A, B, C, D, E, F, G. Now, out of which one is the taxes. So it was the duty of the intending auction purchaser to have inquired what these taxes, where from these taxes are coming. So he should have taken and made an inquiry. And in respect of a property, where from the tax would arise. My lord, 147. In terms of the legal doctrine of the caveat emptor, it becomes the duty of the buyer to exercise due diligence. A seller is not under an obligation to disclose patent defects of which a buyer has actual or constructive notice in terms of Section 3 of the Transfer of Property Act. However, in terms of Section 55(1)(a), in the absence of a contract to the contrary, the seller is under an obligation to disclose material defects in the property or in the seller's title thereto, of which he is aware, and which a buyer could not in ordinary care discover for himself. 148. While examining the effect of an as is where is clause, the fact and circumstances of each case individually, along with the terminology of the clauses governing the auction sale, must be taken into consideration to arrive at the equitable decision. My lord, my most respectful submission, subject to what falls from your lordship and correction. The EOI is very clear. The notice of auction is very clear. It is as is where is basis. The EOI makes it very clear that disclaimer clause and others that you see, you have to go and kindly inspect. I do not want to trouble with those clauses. Once more, what I have placed that those clauses your lordship takes note of. Then, those are my submissions from KC Ninal. Now, my lord, a matter from Surface Act came up before this honorable court. My lord, I'll be giving that judgment also. No, two copy of the fresh copy. That gives me a minute. আরে ফ্রেশ কপি আমি নিজে করেছি পয়সা My lord, I'm sorry, so extremely sorry.
No,
your lordship, wait. Yes. This is reported in 2024, SCC Online, Calcutta 3938. Malad would kindly take paragraph 18 onwards.
2938.
393. Paragraph 18 onwards. Here also there was an auction sale with the auction notice saying that as is where is basis. Now the court, the honorable division bench, while considering that aspect at paragraph 18, the law on the subject has been settled by the Honorable Supreme Court in the recent decision of KC Ninan versus Kerala State Electricity Board, wherein the Honorable Supreme Court was considering several questions, one of which being the implication of the sale of premises on as is, where is basis, which with or without reference to the electricity areas of the premises. The said condition was explained to mean that a sale on as is, where is basis postulates the purchaser would be acquiring assets with all existing rights, obligation and liabilities. When a property is sold on as is, where is basis, encumbrances on the property stand transferred to the purchaser upon sale. Paragraph 18. The Honorable Court referred to the decision in Telangana State Southern Power Distribution Company Limited versus Srigdha Beverage. Malad Srigdha Beverage, I just now placed, while placing Malad paragraph 145 in all probability. Yes, Malad. While placing Malad 145 of KC Ninan, this Srigdha Beverage, yes, Malad, that Srigdha Beverage was placed. So I do not want to trouble your lordship with paragraph 19 because I placed 145 of KC Ninan that deals with this judgment. Srigdha Beverage. Huh? Then, my lord, paragraph 20. The Honorable Supreme Court also examined the doctrine of caveat emptor, which I just now placed. Referred to section 3 and section 55(1)(a) of the Transfer of Property Act and held that in terms of 55(1)(a) of the Transfer of Property Act, in the absence of a contract to the contrary, a seller is under an obligation to disclose material defects in the property or in the seller's title, of which he is aware, and which the buyer could not with ordinary care discover himself. In the case of hand, there is a contract to the contrary. The writ petitioner irrevocably bound themselves to such a contract and they cannot resile from the same. That too after having remitted the entire consideration and after obtaining the sale certificate. Here also they have taken sale certificate. And possession of the property which they have taken. Put up on for auction. The Honorable Supreme Court also pointed out that while examining the effect of as is where is clause, the fact and circumstances of each individually along with the terminology of the clauses governing the auction sale must be taken into consideration to arrive at the equitable decision. The conclusion were held at paragraph 341 of the judgment, subparagraph 1. It was held that the implication of expression as is where is put on notice that the seller does not undertake the responsibility in respect of the property offered for sale with regard to any liability of payment of dues like service charges, electricity, dues of power connection, and taxes of the local authorities. So, my lord, K.C. Niran is clear. Today he cannot take refuge under the judgments what he had cited in the morning. So far as A.I. Chavdani, I have just now shown, my lord, A.I. Chavdani has been considered by the Supreme Court while delivering the judgment of K.C. Niran. So this is because we pose two questions. We pose two questions. Whether it is within my power to refuse him mutation for unpaid dues. And the second, as a corollary which takes the main seat, whether I can claim at all.
Yes.
Whether I can claim at all. So I was now answering the corollary which takes the main seat, that whether I can claim at all. And in view of K.C. Niran, read with the EOI and the notice of auction, I say I have every right in this case to claim the taxes. Because it says that the reserve price does not include taxes. And he wants to push me to show me the door to the liquidator's office. Liquidator is going to show me the shoe. The liquidator is going to show me the shoe. You see that the EOI says the reserve price does not include, it is exclusive of taxes. So I have not collected anything as taxes from him. And if you have not claimed from him, fait accompli. And I'm stuck in that. This is the situation. Now, my lord, our court's judgment. Let us start with the division bench itself. Why I am showing this, your lordship would immediately come to appreciate. This is a judgment of KMC versus Joey Lahiri, reported in 2009 1 CHN, page 829.
829, huh?
Yes. It starts, mutation. KMC is vested with the power to refuse mutation in contingency of non-payment of arrear dues of the KMC on account of property tax. Now, my lord, if your lordship sees page 830, the counsel your lordship sees. I do not want to say anything. The lordship has seen the name. Then, my lord, now I will be failing in my duty. The Honorable Division Bench was considering the proviso to section 183(5), which appears to have been deleted from 2019. So it would be argued against me that this judgment cannot be shown because it based on that proviso, so it has now become ineffective. So I made it very clear. I have shown, my lord, that this is the situation. But your lordship would kindly see.
So it is not relevant, Mr. Mukherjee, to that extent.
Now, there is one more my learned friend was referring to. That is a single bench judgment by my lord Justice, by my lord Justice Vish Chandra Gupta, which is reported in 2012 2 CHN 765. Now, while delivering this judgment, his lordship had taken into consideration AI Chabdani. Now, my lord, would kindly come to, I do not want to trouble your lordship with the first part of the paragraph 14. I have considered the rival submissions advanced by the learned advocates appearing for the parties. The sum and substance of the contention put forward by the learned counsel is that charge under section 232 KMC Act is not enforceable against the transferee for value without notice. That was my learned friend's argument.
Yes.
Therefore, the transferee has no liability to pay. That is also his case. In the absence of any liability to pay, the provision of 183(5) of the KMC Act enabling the respondent municipality to refuse mutate the property in favor of the petitioner except upon payment is bad in law. The submission of the petitioner cannot be accepted. KMC Act provides for two separate procedures for the purpose of recovery of dues. Section 232 of the Act creates a charge and or encumbrance upon the property which runs with the property. In exercise of the right under Section 232 of KMC 232, the KMC can proceed to sell the property for the purpose of recovery of its dues. The second right reserved to the KMC is under 183(5) of the Act, by which Kolkata municipal, that refuse part will go because the 183(5) has been amended. But 232 remains unalloyed. Now, the charge, my lord, after leaving that part, in between your lord, in middle your lordship would find the charge it was held by the apex court would not apply to a transferee for value without notice. That is Chabdani. The honorable court was taking consideration of Chabdani by the apex court would not apply to a transferee for without notice. The apex court examined the matter in great detail and opined that the transferee in that case did not even have a constructive notice of the charge. In the case before me, it cannot be said that the transferee did not have any constructive notice of the charge. The terms and condition of the sale discussed above would go to show that the recovery officer who sold the property was in doubt with regard to the same, which he also had indicated. Now, my lord, your lordship would find paragraph 2. The letter dated 8 July 2010 referred to a clause 2 of the prayer A quoted above in annexure P9. The writ petition by which the writ petition was informed that he has to clear outstanding dues and to submit no objection certificate for the purpose of mutation. He was also requested to submit the no objection certificate at an early date. Otherwise, the mutation case was likely to be cancelled. From the enclosure to that letter, it appears a sum of rupees so-and-so was due and payable inclusive of penalty, and it also appears that the sum of so-and-so was lying at deposit of this suspension. Now, my lord, this amounted to constructive notice, and the terms and condition, particularly the one 9.1.10, was a clear notice that I do not take any responsibility of the dues like taxes, charges, and so on and so forth. Kindly be diligent. Make an inquiry on your own and find out what is there. 7.10. 7.1.10.
No, it's 7.10, which he's talking about.
Yes.
He talks about taxes in that.
Yes. It includes taxes. In no uncertain terms. Is exclusive of all taxes, levies, duties, registration fee, and other. Page 48, I showed. So, my lord.
এটা দুটো মানে একটা হচ্ছে কি বল একটা হচ্ছে যে ওই যে বিট করেছিল সেটা বলেছি ডিডাক্টিং অল দি ট্যাক্স নাম্বার 1 নাম্বার হচ্ছে যে আমি এর বেসিসে যেটা ট্যাক্স ডিডাক্ট করে বিট করেছে আমি আর
So, my lord, what things I take it from my learned junior. So, while the good amount was put in, he has discounted for all these things. That is our submission. So, he is aware of, might not be he is saying it on papers, but he is aware of. He has been made aware of. Might not be the actual amount, and outlines are there. So, he had constructive notice. So, my lord,
cannot go.
And naturally, on the basis of this clause, I cannot go before I have submitted at the cost of repetition. I again say that, my lord, I cannot go before the liquidator. So, my lord, taken the entire thing. Oh, yes, I'll be relying on that. That so far as there's one coordinate bench judgment shown to your lordship, that is of my lord Justice Devanshu Koshak. আরে আমার কাছে কপি আছে তো দে না তোকে তো দিলাম কপি এক কথার দুটো judgment. That is Grashim Enterprise, my lord.
Yes.
My lord, what I understand. That 2018 SCC online Calcutta 9630. Now, what I understand from my learned junior who appeared in this matter, corporation preferred an appeal. While the appeal was pending before my lord Justice Odijit Banerjee,
yes,
the Grashim Enterprise came into a settlement.
The matter was made CAV.
Was made CAV. At that juncture, they came into a settlement with KMC and paid the entire dues, which was claimed by the KMC. So ultimately it was not proceeded. This is the, if your lordship wants, I can take and submit a
APO 228 or 280.
I can submit a
No, I
letter
have
to
the copy, my lord. I have the order copy, my lord. It was settled, my lord, out of court.
Yes. By paying the entire amount.
That is not recorded here, my lord. It's amicably settled.
I can give it my record shows that the entire amount has been paid.
Penalty বাদ দিয়ে
Yes.
পেনাল্টিটা বাদ দিয়ে
Without penalty and interest, the principal amount has been paid, and
some interest also,
and that has been settled. So that cannot be, my lord. If it is settled ultimately this cannot be relied upon if the parties settle it. So, my lord, your lordship takes is considered in its entirety. I submit most humbly with all respect that the dues which has been claimed by the corporation while granting for granting mutation
Yes.
has to be paid by this option purchaser who had notice right from the day one till now. And in view of K.C. Ninan and our division bench, the very clause as is varies basis and no recourse basis has been explained by the honorable three judges of the honorable Supreme Court and read with the division bench in the matter of in 2023 10 SCC page 60 at paragraph 46. Do I give your lordship this copy? I have marked it. Only your lordship pardons me. I have said paragraph 46 at the left hand side top corner, which has explained K.C. Nina. So, 2010 কত এসেছে পেজ 60 এটা মনে আছে কিন্তু পেজ 60 দেখ না ওটা কত এসেছে দেখুন তো 10 ভলিউমটা একটু ভলিউমটা দেখে দিন
Pay
he wants the reference. I don't have the second copy.
2023 10 SCC 60.
10 SCC page 60 ঠিক আছে paragraph 46 ঠিক আছে so that has also been explained. Now my learned friend was IBC ওই যে terms and conditions of the দেখিয়ে দিলাম তো terms and conditions আবার এখান থেকে যাচ্ছি so my lord view taken from any side my lord most respectfully this he has got no case in the petition.
Yes.
My lord, since Mr. Kaur, my lord, is engaged in some other court, my lord, kindly give us another date, my lord, so that because he has given already 3 citations that we need to go into, my lord, because already tomorrow, my lord, anytime 15 minutes to 20 minutes, anytime.
Tomorrow we can't have it. Original side day is only on Thursdays.
Yes, my lord. So, my lord, next Thursday, as Mr. Kaur was suggesting, my lord, after the vacation, I'm leaving it to your lordship, my lord.
After the vacation, why?
Prior to vacation.
What are you saying?
My lord, I'm not. But anyways, my lord, but next Thursday, my lord.
Heard the entire day.
Yes, my lord. Yes, my lord. Yes, my lord. I must say, my lord. My lord, next Thursday.
Not that court which hears the matter and then give you date. Please, I'm hearing it to finish it off.
Only next Thursday I will not be there. That's why I said, my lord. Only that reason.
What's the point of wasting time?
No question of. My lord, we will give a reply. Allow us 30 days time in the 30 minutes time, my lord. In the meantime, my lord, to distinguish all those 3 judgments.
You can do that.
My lord. We need to, my lord. Because auction, anyways, my lord, we will submit on. Do we mention now? Any days?
What submissions you have to make? What is there to reply?
My lord, since my lord, only these 3 judgments we need to distinguish, my lord, and to
distinguish it.
But we will obviously file our note, my lord, but we need to distinguish.
File a note and distinguish.
My lord, we need to distinguish.
File your note.
But kindly hear Mr. Kaur, my lord, on that day, my lord, only 20 minutes to time, my lord,
We don't have that much time. The luxury is not there for us.
But there is no question of luxury, my lord.
This luxury doesn't exist. Today I've kept the entire day for you.
My lord.
See if you can call Mr. Kaur.
But he's on his legs, my lord. That's why.
How much time will it take?
Before
we'll finish it off.
Before
I have discharged my board.
Yes, my lord.
I'm sitting here only for this matter. I'll finish it.
Second of yes, my lord.
So this is the whole. I'm not going to pass it over. I'm not going to give you time now. Let's finish it off. It's a waste of judicial time.
There is no question.
Just find out.
Yes,
I'll come back and hear you, but we'll finish it.
Yes, my lord.
It is fresh in my memory, then you want to do it after.
No.
And I'll forget everything. You don't want judgments, huh? You just want dates.
Judgments, no question of dates. Only next Thursday I will not be there. That's why I said. Well, otherwise, my lord has already, my lord.
Senior is not.
Whole day has been given, my lord. Whole day has been given, my lord. Why should I, my lord?
So let's make use of the whole day, na?
my lord.
Let's make use of it.
Yes, my lord.
Something profitable should come out of it.
My learned friend, my lord,
All right, I'll come back in 10 minutes. You ask,
okay, my lord.
find out where Mr. Carr is.
Yes.
We still have time.
আমার পছন্দ দিচ্ছিস কেন?
You inform my.
Yes,
I'll finish it, Mr. Carr. That's why.
I'm really sorry, Lord, really sorry. But unfortunately, the matter which supposed to have taken 5 minutes, it's just spilled over, Lord. I'm really sorry. And I was before a division bench, Lord.
No, it's fine.
I'm so sorry.
No.
Please accept my apology.
I
Lord,
thought, I thought since we have kept the day for this.
No,
let's finish it
absolutely.
off.
Lord, I'll just take, Lord, 5-10 minutes to conclude my submission. Lord, the law we have all seen. It's only, Lord, the fact and not one judgment that my learned friend has cited. Now, Lord, factually, my learned friend is relying on 2 or 3 clauses of the sale notice. Lord, if your lordships kindly come to page 48, this is one of the clause that my learned friend is relying on, 7.1.10.
Yes.
If your lordships kindly sees, it says reserve price for the sale of assets of the company is exclusive of all taxes, levies, duties, or any registration fees or any other fees, charges. Now, Lord, my learned friend says that once it says exclusive of all taxes, levies, duties, that means the tax was kept out of the liquidation proceedings. That is his contention. Lord, I would say that if your lordships kindly come to page 87, this has been clarified by the liquidator himself in the deed of assignment. Page 87 kindly sees 6.2.
Yes.
Which talks about outgoings, including municipal rates and taxes. Has your lordship got that? Yes. Taxes, duties, assessment, outgoings, and impositions in respect of the demise module payable to any authority or government or any other appropriate authority or otherwise, which during the tenure of for the present sublease be payable, imposed or assessed on the said demise module, whether payable or by the owner or sublessee or demise. The transferee sublessee shall also be liable to pay dues, arrears, outstanding, etc. for the period of the present sublease.
Yes.
So, Lord, the liquidator has made it very clear that, Lord, past municipal taxes was not my responsibility, because while assigning the lease in my favor, the liquidator has incorporated the clause 6.2. Now, Lord, the other aspect of the matter is, kindly sees, it says reserve price for the sale of the assets of the company is exclusive of all taxes, levies, duties, and registration fees or any other fees, charges. This really, Lord, talks about the transfer post sale. All that is required. Say, for example, Lord, taxes is TDS. There has to be a deduction of TDS so far as the payment is concerned. Then, Lord, levies, there will be stamp duties for the purpose of, Lord, assignment and all that. So, Lord, this really talks of a sale and the post-sale consequences. This really, Lord, does not include the municipal tax, because, Lord, the tender or the notice, the expression of interest should have a clear clause saying that public duties and public taxes has to be paid separately. Otherwise, Lord, this is not restricted to corporation tax. Tomorrow, Lord, some other authority can approach and say that you have to pay the tax. Income tax might say that you have to pay, there are outstanding dues. That can't be. The public dues, there has to be a separate clause. And that is, Lord, what the first judgment that I cited, AI Chabdani, clearly says that public duties or public taxes, there has to be a separate clause. It's not something which is inbuilt and one has to read through and interpret that there is some provision for payment of municipal tax. That's one thing. The other clause that my learned friend relied upon is 7.12. Kindly, Lord, take 7.12 at page 49. The purchaser shall bear and pay the applicable stamp duties, registration fees, and all fees and expenses payable for registration of documents, taxes, GST, etc., and all other duties payable in connection with purchase of sale of assets. Therefore, Lord, this is again for the purpose of transferring the assets, whatever requirement that has to be paid, that has to be borne. Because, Lord, otherwise the title doesn't pass to me. For the purpose of that, Lord, this clause is there. But this does not take care of the past dues of the company which has gone into liquidation. And Lord, my learned friend has also relied on clause 9.4 at page 50. Says the information contained in the invitation is substantially based on estimated information, opinions, and so and so. The invitation does not amount to recommendation either expressly or by implication with respect to the company or other entities, etc. Kindly see the last. The liquidator shall not have any liability under any law, statute, rules, or regulations for any representation, warranties, conference, etc. The liquidator is not protecting itself. This disclaimer is by the liquidator that you cannot sue him for any of the fallacies that you may find out later. This is a disclaimer to the liquidator.
Yes.
And in any event, Lord, he expresses it as is varies. So, but he is taking extra precaution that somebody may not come back and tell him that you did not disclose this, you did not disclose that. And that is the reason why he has taken this disclaimer. Now, Lord, these are all on the terms. Lord, interpretation of terms is obviously, Lord, it is within your Lordship's jurisdiction, but I can only assist your Lordship. Lord, my humble submission is that a statutory due of a corporation is a public due. There was no notification that I have to bear the public dues. Lord, therefore, we will go by the general law which is applicable in case of liquidation. And the liquidation law clearly says that once the liquidator sells the asset, the charge, if any, on the property that they had shifted to the money that the liquidator had received towards consideration. And Lord, not having exercised their right under the statute, they have really waived their right in terms of the claims that was to be filed before the liquidator. That's one thing. The other thing is that, Lord, now there is an overriding effect so far as IBC is concerned, because this is a sale, Lord, which was under IBC. And Lord, 238 I have shown to your Lordships have an overriding effect so far as Kolkata Municipal Corporation Act is concerned. So, Lord, any exercise of power now under the KMC Act is a past sort of action. The other thing is, Lord, this judgment. If your Lordships kindly have a look at this judgment, there is a, this is 2023, 14 is. Yes. There's a short paragraph. Lord, if your Lordships kindly take paragraph 1.
Recovery of electricity dues.
This is not under, this was a sale under the SURFACE. And Lord, the SURFACE, the scheme is totally different. Because the person who is buying the property or the assets, they are going to draw, Lord, the electricity from the same point where, Lord, the electricity has been disconnected. This provision in under the SURFACE Act is totally different, because this is in liquidation, Lord, there is a scheme controlled by a legislation. Unlike that, under the SURFACE Act, there is no liquidator. The sale is conducted by the bank, bank takes the money and goes away. Yes. So there is no question of any similar provision as Section 53, which is contained in the Companies Act, which invites the creditors to go and lodge a claim. Lord, what has happened is this. Lord, so far as liquidation is concerned, it's a company which is dead. So the estate of the dead has to be dealt with in a particular manner. That is the scheme.
Right.
Here, Lord, what is happening? The bank is taking possession of an industry which may or may not be dead, because they declare NPA, then, Lord, Section 14, they take possession, and, Lord, they hand up the possession in terms of the Securitization Act. So, Lord, there is This is not a case of insolvency or liquidation. This is a case where, Lord, in case of a running business, one is handed over, and Lord, obviously the consequences are, that is what is discussed in this judgment. But Lord, in my humble submission, Lord, IBC was not considered at all here, because it was not one of the situations which was to be considered, which is there, Lord, in the judgments that I have cited. So, Lord, once it comes under the purview of the Companies Act in a stage of liquidation or, Lord, IBC, the situation is totally different. The liabilities are completely different from the situation that is contemplated here. Lord, these are my humble submissions. Just give me one. And in fact, Lord, I don't want to, there is a judgment of the Supreme Court where, considering section 238, an income tax due, said that was overridden by reason of the insolvency.
Small judgment.
This is just
This is
insolvency. Insolvency. It is insolvency. Kindly see, Lord, the judgment is just 2 paragraphs. Given the section 238 of the Insolvency Bankruptcy Code, it is obvious that the code will override anything inconsistent contained in other enactment, including Income Tax Act. We may also refer in this connection Dena Bank, etc. It's making it clear that income tax dues, being in the nature crown debts, do not take precedence even over secured creditors who are private persons. This only says, Lord, the 238 will prevail, even in respect of income tax debts. So, Lord, these are my submissions. I am extremely grateful. And once again, Lord, I apologize kindly.
I just wanted to finish it so that, you know.
And Roshamay Das, my learned friend's the judgment that my learned friend has relied upon, much water has flown through the Ganges after that. Your lordships have considered the other judgments that I have cited.
Yes.
Lord, now, Lord, the Supreme Court has taken a completely different view.
Only one line answer to this.
Yes.
As is where is basis. As KC Ninan has explained, so wherever in the auction notice it is there, so naturally that follows.
CAV,
Much.
because next week again we'll be busy with that.
But if you next week, if there is pressing, Lord, motions, your lordships can keep it after the vacation immediately.
We will see.
Yes.
We have already extended the interim order.
What subject to
Yeah.
what falls from my learned senior friend. That so far as the original side is concerned, after the vacation, if your lordship could consider to take original side, now your lordship is taking for only one
day.
At least give half a day to it.
We will do that.
Your lordship considers.
No, that's already in my mind, you know, not only for that, even
in fact, your lordships can,
if I'm here on this roster, I have
that half a day, your lordships can take only motions.
Right.
The hearing matters can be kept
In
for
the
the
second
whole
one.
day. That your but there's an interim order which is expiring today. Your lordships may kindly extend that.
CAV too.
It's a CAV, but in case, Lord, they take any.
Do anything. Don't do
Because they do none.
CAV matter what time?
I only.
They will not do anything.
My learned friend is there, but Lord, sometimes, Lord, their officers.
You have filed something today?
Oh, that they have filed their opposition.
Opposition is there.
Affidavit in opposition filed on behalf of the respondent number 2 and 3 is taken on record.
Report was filed earlier.
Third party, CAV.
Much.
The interim order, Lord, your lordship is not inclined.
I can extend it, but
Kindly extend it till disposal.
interim order granted earlier is extended till the final judgment.
Much okay.
Final judgment.